My lord, praying for the leave to file because it is an application for transfer of the matrimonial case from Siliguri to Hooghly.
Why do not have determination?
Uh,
Section 24, I do not have determination. Yes. Yes, Mr. Chatterjee.
My lord, this is item number 342, fixed under the heading fixed matter.
Yes.
When your lordship was pleased to take up this matter before the vacation, before the
Yes, yes.
summer holidays, your lordship was pleased to fix up the matter today.
Today it was fixed.
Today
it was fixed.
Date was fixed. But it does not reflect in the list. Mr. Basu is on other side. He will not come.
একটু চেক করে নিন, উনি বলছেন আজকে
In the order sheet is not with me, but order sheet.
অর্ডার মিস করেছেন তাহলে।
Your lordship specifically inquired me whether I shall be here after coming from
Yes,
Delhi.
yes. I think a mistake has been.
Very well.
Any time? Did I fix any time?
After recess.
After? Huh? List of the time টা তো আজকে 2 PM কি আছে? 2 PM?
Well, today your lordship kindly do not do it because Mr. Basu is other side. He will say my junior will not bring the brief because in the item number 342, nothing in the indication list. If I am there, I ought to have been not brought my brief.
All right.
So, my lord, your lordship kindly indicate.
I will indicate that the
the
date.
next day and
All
indicate
right.
in the list.
All right.
Fine.
একটু মার্ক করে রাখুন আমাকে এ করা।
Maybe permission to mention one matter. Against the execution, I have filed. This is the last.
What do you want?
Expertise order.
What do you want now?
Can you take up this matter? 19 is the date fixed for last time.
When the date has been fixed?
19. And then 19th June 2000.
19th June.
Yes.
What is the item number?
Item number is.
Why did you not mention yesterday?
Yesterday, I have also mentioned.
Yesterday you have mentioned.
Yes, but I
Please
think-
check up. I think some date has been fixed. If you have mentioned yesterday, please don't mention today.
I have annexed this. 19 is the last.
Sorry, please ascertain. Please don't have to give the slip. Please ascertain. What is the date fixed? From your mentioning slip which you have added up yesterday.
My lord, may I privately mention item 226, my lord?
Item 226 of the days list.
Days list, updated matter 1, my lord.
You
But
mentioned
now-
yesterday.
No, my lord.
Why did you not mention yesterday?
Kindly accord it.
What is the urgency?
Urgency lower court date is fixed, my lord, for.
When? When?
For 16th is the date fixed.
16th.
16th. Tomorrow, if you not.
16th June করে রাখুন এটা। Item number?
Item number 226.
226, 16th June.
16 or 17 fixed.
17th?
17th.
17th June.
Tomorrow is the date fixed in the learned code below. It was brought to your lordship's notice yesterday, but unfortunately the matter has not appeared in the list for whatever reasons. I was just reading.
Not appearing in the list.
It is not. It is appearing in the monthly list 1172.
It is appearing. Yesterday you have mentioned.
Yes.
Please check up whether date has been fixed.
They say that they were waited till late in 6 o'clock.
6 o'clock. I left at 8:30.
Find it out.
I left at 8:30. Please check.
Very.
I left at 8:30. I think after your junior left.
Kindly to mention for arbitration, item number 1186 of your lordship's monthly list, my lord.
Yesterday you have mentioned.
No, I couldn't, my lord. I couldn't, my lord, because I have a matter to take up at.
Then next Wednesday.
My lord, kindly, my lord.
No.
My lord, may I be permitted to mention, my lord, in today's list, item number 290, my lord, section 24 application under CPC, my lord.
CPC.
Yes, my lord.
Item number?
My lord, 290, my lord.
291. Order করে
90,
দিন।
290.
290.
My lord, the next date is fixed on 25th of this month.
I do not have determination. 290. For want of determination, let the matter.
Number 584.
582.
584.
Of the monthly list.
Yes, my lordship.
580.
My lord, may I be pleased to mention a contempt application for listing?
Madam, why you did not mention yesterday? Please come on next Wednesday. Non-prosecution, hand over the slip.
My lord, may I be
Inclusion not today.
May I be
Please come on next
mention
Wednesday.
only for correction only.
Correction, hand over the slip. Yes, call the list.
Out of extreme urgency, my lord, may I permitted to mention for inclusion in the list, my lord.
Why did you not mention yesterday, Mr. Bhattacharya?
Every
day mentioning, yes.
The court is not granting, Monday is a date fixed in the court. My
You
lord.
have mentioned yesterday.
I could understand, my lord.
Item number 67 in my lord's list. Order can be passed today.
Item number 67. Today. Item number 67 এর order করে দিন। The learned advocate appearing Yes, call the list.
Item number 1.
Item number 1 and 3 may be taken up together because we are not proceeding with the matter. They have
No.
settled.
This is that matter where both the parties say that they do not want. Item number 1 separate order করবে না? Item number 1, the learned advocate appearing
Same matter for the husband.
yes. Same order,
1 and 3.
same order. কিন্তু separate
Two.
Lordship, item number 2, it's a section 24 matter.
section 24 CPC.
Lordship, may this
Want
matter.
of determination, let the
4.
My lord, matter fixed on Friday, but suddenly it appearing, my lord. I'm led by Mr. Parthopatim Roy.
yes, very
When we don't know
fine.
my lord, what is about the can number 2, they did not serve the copy, my lord.
Yesterday you have not served.
My lord, there was some difficulty, your lordship. My lord, we have prepared it. My lord, we will be serving within the course of the day, your lordship. This is the copies.
List this matter in the next week under the same heading.
My lord, I was just indicating, my lord, this is, my lord, recalling
Don't have to indicate.
application.
Please
we have
serve a
made.
copy upon them first. Thereafter you will indicate. Yes, call the next matter.
Great, my lord. By the leave, see that.
Number 5.
Lordship, this has come up for correction of the order, your lordship.
Correction of the order, madam. Pass over what pass over you want.
Lordship, the order dated 23rd May 2025, the last order, your lordship.
Yes. What is the correction required?
Your lordship, first page, last line, your lordship. It has been wrongly recorded proceedings in miss case. This case number has been recorded wrongly, your lordship.
What should be the correct number?
It will be miss execution com 14 of 2024. It's there in the 16th April order, your lordship. Last third page, your lordship. Second last paragraph.
Mis-execution from 14 of 2024.
Yes, your lordship.
That should be a,
Yes, your
this matter.
Lordship, this is my application. Lordship, this has come up for extension of interim order. I'll hand over the last order. Lordship, so our order 26 application was dismissed and thereafter it was fixed for issuance of writ on 7 June. We had
Why expense of interim order? No interim order was passed.
Lordship kindly
When interim order was passed? No interim order was passed.
Lordship kindly come to the second last para as the
Yes.
as the matter is sub judice before this court, let steps be taken for a one.
No, interim order was passed.
Lordship,
Yes,
that
yes,
direction
this matter. Please move. Yes.
Lordship, this is a very fairly simple matter. Lordship, this is recovery of possession is filed against us in respect
Please,
of
please give me a minute. Please give me a minute. You are challenging the order dated 17th of May 2025.
Lordship, I am.
Please give me a minute. Please take your seat. Yes. What is the matter?
Lordship is a very short point.
You
Lordship, I am for the petitioner. I am for the defendant in the suit.
are the judgment debtor or the decree holder?
Lordship,
You are
I'm
the judgment debtors.
the judgment debtor.
Yes.
Lordship, so what had happened is short involved. Lordship, suit for recovery of possession decree was passed against me on 16th of February 2016. It filed a title appeal. Now that title appeal was dismissed for default on 29th of May 2019. Thereafter, we had filed a restoration application along with an application stay of the decree. Now that application for stay was allowed on the ground with the condition that we have to deposit 1 lakh as occupation charges. Challenging that part of the order, we had come before bench of this court. That order was set aside. I'll take your lordship through that order.
What happened after that? Please give me the facts first.
Lordship, that order was set aside solely on the ground that the application for restoration first before stay. Now, thereafter, we had filed an application and direction was given to the expeditious hearing of our restoration application along with our probation application. Thereafter, we filed filed application for expeditious hearing. Lordship, that goes back in 2019. That was not heard. That application was not heard from time to time, and now recently in the execution proceeding, we had filed an application under order 6. That application, the order, she would see that the application was set aside that the previous application was set aside by the bench. The ground, but lordship, if lordship sees that order, lordship would see it set aside just on one that the restoration application had to be first. The lordship would kindly appreciate in the title of our arguments have already concluded. Our arguments concluded.
Your arguments have been concluded.
Our arguments are concluded. Our argument has all along been that application the suit under the our argument is that our argument is concluded. It is just the argument.
When the argument of the respondents are fixed.
Lordship, the next date is the last date is 7th of June. Thereafter, the next date is Lordship,
what is the date fixed in the execution case?
Lordship, that has not been updated. The last date.
You are saying that in the appeal.
No, the last date was fixed on 7th June.
7th of June, the last date was fixed.
Last date was
fixed. The date fixed in the title appeal.
In the title appeal, lordship, I just indicate. Just take. Lordship would kindly process this. I'll come back. I'll come back with the next date. Lordship,
come at 12. Come at 12 noon.
I will. I will.
Specific instructions. What is the next date fixed in the title appeal?
I will. Lordship.
What is the next date fixed in the execution case?
Next date is, I have checked, Lordship.
Please ascertain whether it might be that in the meantime the date has been fixed.
I will.
Which court?
This is fast track to Shalda, Lordship.
All right. So please come at 12.
I'll come back.
Those instructions.
I'll come back.
My lord, I am appearing on behalf of the petitioner. Direction, I have served the copy upon the opposite party, my lord. Where is he? May I start my case, my lord? Where is your affidavit service? My lord, affidavit is not ready, my lord, because the matter was taken up yesterday, my lord. All right, tomorrow. File affidavit service tomorrow. My lord. Yes, tomorrow. Next.
8. Lordship, I am appealing for the petitioner. There was a caveat I have served. Affidavit of service, sir, Captain. Lordship,
Yes.
Lordship, in the code below, this was suit for specific performance contract. And in the specific performance contract, the defendant executed his signature on the sale agreement for sale.
You are the plaintiff.
I am the plaintiff. I am the plaintiff petitioner.
Yes.
In the agreement for sale, the defendant executed his signature. During the cross-examination, he denied it. And he repeatedly stated that they kindly see the impugned order, Your Lordship.
Where is the cross-examination?
Cross-examination, Your Lordship.
What is the name of the defendant?
Nimai Chandra Sardar.
Nimai Chandra
Sardar.
Where is the cross-examination? Yes, Mr. Banerjee, are you carrying your cross-examination? Please give me your cross-examination.
Lordship, kindly see.
I'm carrying the chief.
You're carrying the chief.
Chief, I have.
Not the cross. Why?
No.
Cross is something against you.
Lordship,
Could not be obtained, my lord.
Lordship, in the
Copy was, my lord. Sir,
Lordship, in the order it has been stated.
Sir, when you have lodged the caveat, you must be having the papers.
should have, my lord, taken out a certificate.
So,
Should have.
Lordship, we kindly see the order impugned.
yes.
It is stated here that the signature on the document does not belongs to me. I cannot put my signature in a such nice manner. That he is denying. Against that, Lordship, we made a petition under 26 Rule 10A. That was rejected. The learned court came to a finding that on comparison of two signatures, namely, it is very clear they are different, and the person apparently did not sign on the difference. It is very clear to naked eye and does not require an expert opinion. Lordship, we are on this. The court can examine, but it should be sent to an expert. There are so many judgments. We have only prayed it will be sent to an expert. The court directly denied it.
Yes, Mr. Banerjee.
Sir, kindly considers one aspect. In the written statement,
This is not your signature.
No, I've denied it in the WS.
So let the
Denied that, my lord. My lord, kindly considers.
let the expert say so.
And
But in my chief, in my written
Yes,
statement,
yes.
in my chief,
Expert will say so.
in my cross,
So it will be.
my statement is consistent.
Yes, yes. Your statement is consistent
But
that
at the end of, my lord, the cross-examination, at this stage, my lord, my lord,
There are several, Your Lordship.
Second, sir, excellent.
There are several.
you are the dependent. You are not in a hurry.
There are several.
You are not in a hurry.
There
So let the expert examine.
My lord, the
I
court
said
has,
it's
my lord, kindly considers the court has the power.
Court
to
has the
examine.
power.
When, my lord-
23, I am aware of that.
My lord, kindly.
And court is also the expert of all experts. I am aware of those provisions. Court can. So I can direct you to put your signature in court. In court, you will put your signature. That will be sent for comparison. That also I can do.
My lord, the court has already.
If you want, you can put your signature here. I will send this along with that.
My lord, kindly considers, my lord, the court has already, my lord, compared the signature, my lord, in my that has been put in my lord, the witness statement.
Yes, yes.
But that
Let the
statement,
court-
my lord, that signature and this signature, my lord, the court has verified and has, my lord, come to an opinion.
So Banerjee, you should invite examination when it's not your signature. Why are you so afraid of that?
No, it's not about being afraid, my lord. The court had, my lord. If the court had.
You are considering about the delay. I will expedite that.
My lord, no, kindly considers, my lord, one aspect. My lord, the court had the power, my lord, to do
Yes,
that.
yes, I am not disputing.
My lord, the exercise is power.
Even then, when it comes to examination of handwriting, it has to go to the expert. So the court has the power. Naked eyes, let the expert give a finding.
That's your.
So there will be a double finding in your favor. Court's finding as well as the expert's
My lord,
finding.
moreover, my lord, the commissioner, even if my lord, there's a commissioner report, my lord, I'm carrying a judgment, my lord, of the Honorable Apex Court, my lord.
Lordship, I have cited.
Court, my lord, that is not even
That is not sacrosanct.
that is not even conclusive.
Then also consider. That is why you know all these. That is not sacrosanct.
Cited.
It will only be a piece of evidence which will be considered along with all these evidences.
That's all.
Your statements in the cross-examination and chief. Along with that, the court will finally decide
That was
whether it's actually your
It
signature
cannot, my
or
lord,
not.
only one my lord, humble submission, my lord. It cannot be a mechanical process. Any application, my lord, of
Mr.
four, my
Banerjee,
lord, of four paragraph
Mr.
application.
Banerjee, show me your written statement.
They have not annexed.
Yes, yes, that is why I'm asking you. Give me your written statement. What is your specific stand in the written statement?
Lordship.
Sir, please take your seat. Please take your seat. Please take your seat.
A loan in substance, they say, my lord, it's a agreement.
No, no, what is your stand with regard to this agreement? Please show me from your written statement.
Chief WS. WS, my lord,
You are not carrying.
kindly, no, no, my lord, I was.
Then come tomorrow with the.
Lordship, they have written statement has stated that
That is the written statement. Show me the written statement.
it is, but what have they stated? They have stated.
All right. Come tomorrow. Please bring the written statement. Plaintiff you have annexed.
Plaintiff is there.
Plaintiff is there.
Please bring the written statement. Please bring your entire evidence.
That has my certified copies to me, my lord.
Why certified copy?
My lord, the chief is there, my lord, the
Cross-examination part you don't have.
Cross-examination certificate copy is not.
You have the copy of the cross-examination. Sir, how could you draft this petition without the cross-examination? You are challenging an order, rejecting
Lordship,
without the cross-examination. Only 2 extracts in the impugned order you could draft a revision application.
Our main challenge is regarding handwriting expert. I am cited to judgment, your lordship. It is stated that even in the evidence stage, it can be sent to an expert. Lordship, I have cited the judgments. They are saying so.
I'm not on the stage. I'm not on the stage. Whether
Because I was an lordship, I was an advocate on the record there. They have stated in the
can you bring this copy of the evidence tomorrow?
that I have to see whether I have it or not.
List this matter.
See, and
it is service kept on record. If it is service,
I am led by Mr. Partho Pratim Rai. Lord, kindly takes up the
use
matter.
the busy counsel. Please start.
Lord, the petitioner, Lord, is the opposite party, Lord, in a proceeding for probate.
No caveat.
Lord, initially what had happened, Lord, the petitioner was the propounder of letters of administration. At that point of time, Lord, the executor did not come up.
Petitioner was the propounder.
Yes, of the letters of administration. At that point of time, Lord, the probate executor did not turn up. Subsequently, Lord, the executor, Lord, turned up and the proceeding was converted into, Lord, a probate proceeding. And Lord, I was made opposite party number 1.
Oh, you are the opposite party number 1.
Yes. Now, Lord, this pertains to, Lord, the will of, Lord, Mr. Shapun Kumar Mullik, Lord, advocate.
Okay.
I don't have any problem in moving between.
Yes.
Now, Lord, at that juncture, when Mr. Mullik died, Lord, he had survived a widow. He was survived by a widow. Now, Lord, accordingly, the widow's consent was there. Lord, the will was not on the watch. Subsequently, during the...
Who are you?
Lord, I am one of the beneficiaries.
Under the will?
Under the will. I am one of the beneficiaries under the will. Now, Lord, during the continuation of this proceeding, of the probate proceeding, Lord, there was an attempt made by some of the relatives, Lord, to establish their caveatable interest. Lord, that was turned down and affirmed by this honorable court. Again, an attempt has been made at the instance of an agnetic relationship, saying that she, that particular lady, is related to Mr. Mollik, and that's why she has a agnetic relationship. Only on the basis of a genealogical table furnished by them, the court proceeded that yes.
What did you produce?
No evidence, nothing.
No, I'm asking you, what did you
But
produce?
I also produced a genealogical table.
According to you, she is not an agnative will.
She has some interest, but not.
Mr.
But I
Kormakar,
have
if
better interest.
even a slightest, maybe you have a better interest. But what is your grievance that he should not be allowed to contest?
Lord, if the person surviving or persons who have given Lord, the consent in the
Mr.
proceeding,
Kormakar, there are two line of decisions. One says no, another says slightest interest.
slightest
If
interest,
slightest
yes.
interest
Lord,
is
Lord,
there,
what I am on is
and what will be, Mr. Kormakar, if you are a beneficiary, if the will is proved, you will get. Probate court does not decide the title.
The problem
So only
is
with
not the
regard to
delay
the
that will
proving.
be. The problem is the delay. First, the problem is the delay that will be caused and
What
the prejudice
delay?
of that. Lord, your lordship knows.
They
Lord,
will
once
file
it
a
is contest,
they will file an objection. I can expedite that.
The other aspect of the matter is, Lord, if the parties who have consented to this probate, if the parties who have consented to this probate are also beneficiaries, Lord, if they are subsisting, Lord, no further interest arise out of that particular estate to be claimed by further beneficiaries or Lord, further legatees. I am on that. This person, this lady who claims to have an agnatic relationship, Lord, traces her title, Lord, 3 generations to ascent from the mother's side, and thereafter, Lord, goes on to Lord, 2 generation descent.
So has some line.
Relation is there. Lord, I cannot dispute that. Relation is there. Lord, but with respect to interest in the property,
slight interest, caveatable interest that comes.
The question is whose interest will prevail.
No, it's not a question of.
If it is a class 1 heir, understandable.
Mr. Kormakar, that will be at the time who will get the property. So it's only with regard to
caveatable interest is also based on that.
Yes. Caveatable interest is also based on that. But at that time, considering the inter se weights of the parties whose interest is much more, it's very difficult.
But if the
attempt contest, it will be at the time of final hearing.
If the act says this particular heir will inherit in exclusion of others, in such a situation, will the question of caveatable interest come in? The question is that.
There are 2 line of decisions. That is why Mr. Kormakar.
Slightest interest.
Yes.
Slightest interest will barge in only in a situation when I am not in exclusion. If the act provides that this particular branch of heir will inherit in exclusion of others, the heirs who are excluded.
Who is the caveator?
Not caveator, Lord Devika Chatterjee, one caveat, Devika Chatterjee. Lord, they serve and come back. They need to be heard.
Oh, no caveat has been lodged here.
No.
I was under the impression there is a caveat.
Yes, Lord, my proceeding.
That will be delayed.
Virtually my proceeding. But Lord, this has to be Lord, decided once and for all. Every now and then, Lord, somebody comes up like a mushroom.
Widow is there. Widow is the party.
Widow has expired. That's the reason. If widow was there, there's no question class 1 heir.
She had life interest only.
She had life interest only. She has expired. The problem is there. Widow was there. There was no difficulty.
Then.
Because if widow was there, class 1
heir. You have a copy of the Hindu Succession Act.
Yes. Hindu Succession. Well.
Achhe, Hindu Succession Act. The executor then.
Not Tirthona.
Come to page
comes to page
39.
62.
Kindly come to page 39.
39.
Yes.
Oh, yes, at that juncture.
Oh, now
Yes,
the
yes.
executor and this opposite part number 1 joined hands.
There is no difficulty.
Yes.
Look, we are sailing on the same boat because I was propounding the will. At that point of time, the executor did not come up. Subsequently, that executor took up the baton. So, Lord, there is no difficulty in our Lord pedestal to stand. We sail on the same boat. Both of us are propounding the will. That's why, Lord, today I am before your Lordship. Else, Lord, I wouldn't have been there.
Yes.
There is no requirement. Lord, at
Yes, where is the earlier order?
Page 39, your Lordship is seeing. This is the first attempt of some of the parties to barge into this proceeding. This was turned down by this honorable court. Sister of the wife. After the death of the widow, the sister of the wife came in.
Yes, there was a direction by this court to inquire into the claim of Devika Chatterjee.
Yes. Page
In
60,
terms
your
of the
Lordship
written
has-
objection.
Now-
Yes, now show me the impugned order.
Yes, kindly comes to the impugned order. 8th April 2025. Record is put up to such and such. It appears from the record that previously applicant Devika Chatterjee hereinafter filed one application as such and such with a prayer for direction on the petitioner to serve the copy of the probate application on her as she intends to contest the probate proceedings. It further appears from the record that the said application was allowed by this court with such and she was added as opposite party number 2. Subsequently, the order was challenged such and such to make an inquiry. The recording is there. Accordingly, the applicant has filed one server copy of the order along with such and such. In petition dated such and such, the applicant stated that she intends to contest the probate proceeding and prayed for direction on the executor served the application on her. On further perusal of the record, it appears that executor has filed his objection on such and such against the said petition, and OP number 1 did not file any objection on the petition, though it appears from the record that all concerned were heard on the petition dated such and such. The said petition was disposed of with the finding that the applicant stands in the agnatic relationship with the testator. Similar, here the court goes. Here the court revisits its own order despite the order from this honorable court. In view of the honorable court's order, such and such has filed one objection stating that the applicant was not necessary party as per the provisions of such and such, and the instant application is time barred application, and the same is liable to be rejected accordingly, which was filed sometimes in the year 2022, whereas the testator died in the year 2017. And only person having evitable interest over the estate of wife was wife, who also died in the year 2018. And furthermore, there is no prayer made for adding herself to be a party in the proceeding, and it is prayed to reject the petition. At the time of learned advocate, the applicant submitted that the applicant is a niece of the testator, as they were descendants from a common ancestor, Nepal Chandra Mollik, and in support of her claim.
Yes, inquiry was made, Mr. Kormukar, pursuant to the direction. Inquiry was made, you could not produce any evidence, they produced deeds and other certificates, and you are also not disputing this agnate relationship.
Not what I am disputing.
You are not disputing this agnate relationship.
But dispute not in that sense.
You are not disputing. First. Secondly, you have not made out any case to show that someone has a better right than this person, so that her interest got extinguished.
That is my specific case.
Show me, where have you stated? How have you proved that?
Not kindly comes to page 83.
Mr. Kormukar, nothing from here. You have not said anything before the learned trial judge.
So kindly comes to page 83 once. Kindly comes to page 83 once.
What is 83?
This is not my objection filed after the order of this honorable court.
Yes. Yes, 83.
Not made by opposite party. Number 2 is subject to proof as having any interest.
Show me, Mr. Kormukar, show me who the names of the persons who asked this applicant to be from inheritance.
Not kindly comes to page 85.
Yes.
This is the genealogical chart according to us.
Yes. So show me your positive statement. Your statement
This
is
is a
that
matter of my matter.
there are persons who will oust this person in intestate succession. Show me that positive averment in
Understand,
the.
Lord, my Lord, statements or averments will be
Yes.
clear, Lord, from page 85. Kindly,
Yes,
Lord, comes to
yes.
page 85.
Who are the persons?
Swapon Kumar Mollik, grandfather Anantopriya Mollik.
No, name the persons who will oust this. Where is Devika?
Lord, Devika, your lordship would not find here.
Yes.
The reason is Devika is claiming through Lord Ananto's father.
Where is Ananto?
I'll take your lordship to that. ওদের genealogy-টা দেখা হবে।
They have also given a genealogical chart.
Yes, they have also given. I'm taking your lordship to that only.
So you have to. None of the your chart is not a comprehensive chart.
Lord, I say my chart.
You have avoided that branch. You have avoided that branch.
That was already there. That was already there on record.
So you have avoided
chart
that.
was
So you have to
already
bring out a comprehensive genealogical chart
Not even
in
comparison
order
of
to.
the two charts will also do. Lord, both the charts are there before the court. So, Lord, comparison of both the chart will also do.
That is why I'm asking
May I
you,
take your
what are the names of the persons who will oust Devika?
Lord, according to us, Lord, these are the names, Lord, Siddhartha De Chaudhuri, Sonakshi Nandan. These are the two names. They will oust, Lord, the Devika. The
From
reason
this,
they are
this
closer.
chart, unless you show Devika in a chart along
I'll
with
take
them,
your lordship to that.
please prepare a chart. Please prepare a chart.
Very good. Lord, may come back tomorrow. May come back tomorrow with the chart.
Yes. After some argument,
I appear for the petitioner. No, petitioner. I appear for the petitioner. The expeditious disposal of a matrimonial suit, my lord. The petitioner is a husband. Wife filed application under section 27 of the Special Marriage Act, my lord. We have
you are the wife.
I am the husband, my lord.
Yes.
There is
Alimony?
no, she is in government service. I have made specific statement in the revision application also that she has not claimed any alimony. Kindly comes to page 4, paragraph 10.
This application under Article 227. The Lord, trial courts are overburdened with these directions for expeditious hearing. If you stop, then file extremely urgent matters, I will consider. Wholesale, it will be these orders. In all matters, time fixing, suit filing, summons served, expeditious hearing application.
2019,
Interim injunction obtained, expeditious hearing application.
2019 suit is.
Maybe.
BP of them.
Next.
11. My lord, 11, 12 and 13 are similar matters, my lord.
Expeditious.
Well, my lord, there are two prayers. Well, I'll tell you, lordship, my lord. This is under the Public Premises Act.
Public Premises Act, I think I have passed an order.
Yes, your lordship did. I have it in front of me, my lord. Your lordship has passed an order in KOPT, which is now Shama Prasad.
Also directed to this order to be communicated.
In view of subsection 4 of section 9. Correct. Following that Supreme Court of Bandi. Your lordship. But here what has happened is the unfortunate situation is from 2022, there is a order by which the eviction order was stayed. There was a direction for making payment of an occupational charges of rupees 15,000 per month. Now, the difficulty is that, my lord, the SOR, which is the, as your lordship is aware,
They are paying occupation charges.
of 15,000 rupees. Where the
But Mr. Bose, if that order was passed, not challenged,
no, my
you
lord,
cannot make a grievance now at
no.
this stage.
my lord, we are asking for
What is
what
the
we
stage
did.
of the appeal?
Pending. We have annexed all the orders from 22 till 25. No effect.
No interlocutory application pending.
Nothing. No, state of the pending.
Any interlocutory application is pending.
Yes, stay is standing, extend, the stay order is
You have said that order has been passed 15,000.
passed, but the stay order is that order of stay is getting extended from time to time.
No, the occupation charge has not been finally decided.
No.
Is it a tentative amount?
It is a tentative amount which is continued.
So I'm directing the stay application for the time being to be disposed of, so you can get a higher amount of occupation charges also.
But as also along with the appeal, because your lordship will see, I mean.
Then you, if you say that you will not be pressing for any higher amount, I will say that yes.
No, I am, my lord, your lordship will kindly just record my
These two
submission.
things cannot go
Correct, I
side
can
by side.
appreciate, I can appreciate.
Either you have to say I will not press for that, kindly direct the PP appeal to be decided. It's well and good. And if you say no, you want then I will direct the stay application to be disposed of. There you get everything. And thereafter the appeal will be disposed of.
Well, let the appeal be disposed of. Well, let the appeal be disposed of. And only, my
The
lord,
lower court records have not yet been received. Why?
it was received subsequently.
And it's your office you have not sent Mr. Bose.
My lord, it has been sent. It has been sent.
When?
It was sent. LCR received 3rd of September. Your lordship will see the LCR has been received, which would
3rd of
be
September of
the
2024.
second last page of the bunch
LCR
of
has been
include order.
received.
Yes, my lord. My lord, there was initially a point of maintainability raised, based on which he filed a writ petition. Writ petition dismissed, appeal dismissed, Supreme Court SLP dismissed.
Do one thing, Mr. Bose. I think it's better if you serve and come back. Let them also. Any other interlocutory application is pending?
No, my lord.
And you have instructions to submit that you will not be pressing for any higher occupation charges. Because you are representing an authority.
No, we had pressed before the trial court. With the trial court has, my lord, there is no recording in the order.
Then I think it's better. I'm directing the stay application to be disposed of. Thereafter, the PP appeal.
Very well, my lord. That is better.
What is the next date fixed?
My lord, the next date fixed is 30th of July. 3rd of July or 3rd? 3rd of July. 3rd of. My lord, may I just indicate one thing? My lord, kindly record my submission.
Well, if your lordship kindly takes the trouble of coming to para 16 once
Para 16 of what?
of the revisional application.
Yes.
My lord, of course, this is our calculation. My lord, according to us, my lord, almost 4 crores is due in the first matter. Towards based on
paragraph.
My lord, paragraph 16, 14, 1-4 at page 7.
Occupation rate of occupation charges 2,500 2,55,562.
Correct. That is not occupational charges. That is the schedule of rates. Today, if I let it out, as your lordship is aware, there are tariff orders of major ports, SORs. This is the rate at which I have to let it out. I cannot let it out below that.
That you
No,
make
what
that
I'm trying to
clear.
say is that this is the minimum list, like a reserve rent. So,
All right, so
this person is paying 15
points open, I'm directing the stay application to be disposed of.
My lord.
Stay application, you have filed your objection.
Yes, we have.
So it's otherwise ready for hearing.
Absolutely. My lord, kindly indicate my submission that we say that as per the schedule of rate, this is just my submission. That so far as in the first matter is concerned, my lord, I'll just hand over to your lordship a chart that we've prepared for your lordship's convenience. Kindly see, my lord, the 3 revisional application. Kindly take the first one. The second column, which relates to CO number 1870 of 2025.
Yes.
And if your lordship will kindly come to the
So these are the
schedule of rates.
monthly occupation charges, 2,55,562 and 15,973.
15,000 is what has been directed to be paid.
No. This is according to 15,973.
Yes. Well, there are 2 plates.
Yes. So one is
the
2,55,000 and another is 15,000.
Correct.
So this is according to you market rate.
No, this is according to the government rate.
Yes.
And I cannot let it out below that.
Yes. Ashu.
matter,
একটা করে দিন নেক্সট ম্যাটারটা দিন
my lord, only these two.
নেক্সট ম্যাটারটাতে লিখুন ওটা পিপি অ্যাপিল নাম্বারটা এ হবে পিপি ওয়ান এইট সেভেন টু
Yes, your lordship.
ইয়েস দাঁড়ান পিপি অ্যাপিল নাম্বারটা দেখি
This PP appeal 21.
অ্যাপিল নাম্বার 21 অফ 2022 লার্নেড অ্যাডিশনাল ডিস্ট্রিক্ট জাজ 15th কোর্ট এট আলিপুর আচ্ছা ওখানে লিখবেন
Disposal of the matrimonial suit. The petitioner has preferred an application for dissolution of marriage under section.
ওই চারটা দিন চারটাতে দেখতে হবে
For expeditious disposal, and the petitioner has preferred an application for dissolution of marriage under section 27 of.
Petitioner is the husband or the wife?
And for the husband.
Husband.
There are a number of adjournments that has been taken place.
What happened to the miss case?
My lord, it's the stage of hearing at present.
This case is at the stage of hearing.
And the applicant, mat suit is at the stage of reconciliation.
All right, so I'm directing the miscellaneous case to be disposed of. That has to be disposed of first. This application under Yes.
The instant application is challenging the impugned order passed by the learned Civil Judge Junior Division Bidhannagar, if you rejecting the stay application filed along with an application under West Bengal Municipal Act against the demolition order.
Against the?
Demolition order passed
Yes.
by the Dhamdam municipality. After
Where is the order of demolition?
Lordship. Page 23, Lordship.
Page?
23. It was passed by the chairman of the Dhamdam municipality, where this honorable court earlier directed to pass the order the board of council. Lordship. And there is a contradiction between the inspection order and the order passed by the chairman, Lordship. There is a
You have not deviated from the sanction plan.
no, Lordship. There is a
Is there any deviation or there is no deviation?
there is a deviation, Lordship, but there is the
If there is a deviation, where is the question of stay?
but observation made in the order and in the inspection is different, Lordship. Kindly see, Lordship.
Where is the inspection?
Inspection order, Lordship, 25.
Which one do you accept? In the order or the inspection? Which one do you accept?
Lordship, there is a there is a three-phase block 1, block 2, and block 3. The discrepancy found in block 2 and block 3. In block 2,
Block 2 and block 3, there is deviation.
Deviation.
That you admit.
Lordship, now
So you regularize that,
Lordship,
demolish that.
I have filed application. There is a minor deviation, Lordship. For that, I have filed application before the Board of Council, but they have not responded. Thereafter, this municipal appeal was filed along with the stay application. Now, the stay application has been rejected, and the main application is pending now. Lordship, now in the meantime, they have.
But what can be done? You have admitted that deviation. Where is the question of stay?
Lordship,
This is a recording.
There is a
And it is also admitted by the appellant that there has been deviation from the sanction plan. This was the admission made by you. So where is the fault?
The notice was served.
But sir, you have admitted in the at the time of hearing. Please come to the impugned order. This deviation you have admitted.
But there is a discrepancy in the order and order passed by the chairman that cannot be.
Where is that? You have not stated that before the learned court.
Learned court did not record the order, but I have.
Then move a review application before that. If you say that you have submitted, it was not recorded, your remedy lies elsewhere, not here.
In application is still pending, Lordship.
That will be decided. That will be decided.
Time they serve notice, and today they are coming to demolish the portion, Lordship. That is why I am praying for.
Which one you admit that there is deviation, let it be demolished. I will protect the other one.
Lordship, there is deviation subject to.
Who are you?
The developer. Petitioners are the developer.
Building is complete or it's not complete?
Almost complete, Lordship.
Almost complete.
Some part of.
How many agreements you have entered into?
Most of the part has been some part sold, some part agreement has been done. Most of them.
So how you will compensate? How you will compensate? Deposit the entire money you received through advance in court. I will say this because the flat owners are to be protected. You have taken money. Did you inform them about these proceedings?
The flat owners not come to before your lordship.
I know that.
Co-sharer.
I know that much. I know that the flat owners have not come.
Has been filed by the co-sharer. They have come.
I am asking if it is demolished, who will be affected? The flat owners.
The developer also
So
will be
yes.
affected.
So how you will protect their interest? You have taken money from them. Made an illegal construction, taken money from them. Have put them in possession.
I have filed an appeal, Lordship. Let there be a decent.
In the appeal, you have admitted that you have deviated.
Not appeal in the.
Yes, please come to the impugned order. You have not read your brief, sir.
No, Lordship.
Please come to your impugned order. Last paragraph, second last line of that paragraph.
Admitted the appeal.
More so, deviation can.
Deviation.
Please.
There is a less, Lordship, less portion. The sanction plan kindly sees the one.
Less portion, let it be demolished. The more portion I will protect.
Kindly sees the inspection order and the order passed by the chairman, Lordship. Kindly sees once.
You are relying on the inspection report.
No, Lordship, that is why that there is the discrepancy between the inspection report and the order.
Which order, which are you supporting? Order or the inspection report? Or both are against you? Which municipality?
Lordship, down the municipality.
Dom, who appears for Dom municipality?
Lordship,
Who usually appears for Dom municipality? That you do not know.
I have to serve them. I have to serve them first, Lordship.
When they are coming to demolish?
Today, Lordship, there is a notice.
Demolition started? Not started yet?
Started yet?
Not
They are
started yet.
coming. They have already informed, Lordship. They are coming.
The petitioner. You want some more stay? Thank you. Yes, next.
16.
My application and the judgment for title suit which is pending the 8 ADG Addis, Your Lordship.
Madam, expeditious hearing applications, why are you making this so bulky?
Given all the orders that have been passed, this particular application, this title suit is pending since 1995, Your Lordship. I mean, this is 2025.
And you have annexed the order twice. First at the beginning, then at the end.
That's how I've been advised by the department, Your Lordship. What to be, if it is certified copy of the orders, we will get to know, Your Lordship, why is this being pending for the past 18 years for the same status?
Yes, what is awaiting for collector's report?
So, once I had filed this trial to suit, the defendants had appeared. Thereafter, all of that has.
Collector's report, the agreement has been impounded. It has been sent for valuation. So, madam, how can it be expedited now?
Make myself clear, Your Lordship. The collector's report as of today, I mean, in 2025, the order was passed in 2007, Your Lordship. That a collector's report was awaited. Since 2007 till 2025, Your Lordship, nothing.
Unless the collector's report comes, suit cannot proceed.
Like, no steps have been taken by the department either. There is a
That is a different thing altogether. Yes. This application under Article 227 of the Constitution Yes, who is appearing? None appears for the petitioner. The
behalf of the petitioner, my lord, my innocuous prayer, my lord, to expeditious disposal of, my lord, the eviction suit instituted by the petitioner's fathers, my lord, under the old act. My lord, till date, my lord, 17(2) has not been disposed of, my lord.
this
My lord,
application
there
under
is a
Article
direction under
This matter at 12 p.m. Item number 2. যেটা fixed item.
Yes.
Lordship, the title execution in the code below is fixed on 6th of August 2025, the next date.
Title execution is on 6th of August.
Lordship, sorry, the title appeal, the miss case, the title appeal is fixed on 6th of August 2025.
And title execution?
Title execution, Lordship, even it is not updated on code, but I have been informed by learned advocate. It was fixed on 19th of July 25.
19th of July 25.
Lordship. Taking lordship types of rather than
Asun. By the order impugned,
19.
My lord, I am for the petition. You are for the opposite party? I am for the petition in next matter, 19. I'm sorry. Well, dear Lordship, I have challenged the dismissal of my application under 151, whereby the police assistance was not given to me. Rather, the application, same application under 151, which was moved by the opposite party, that was allowed. And wanted police help for what? Police help in order to protect, in order to comply with the injunction order. Show me the injunction order. Injunction order, Lordship, kindly come to page 28. My lord, this is the injunction order. My lord, may I read the ordering portion? That the petition under order 39 rule 1 and 2. Page 28. 28, my lord. No, 20. Yes. Both the parties are directed to maintain status quo. And thereafter, Lordship, the opposite party were disturbing. Give me a minute. Yes, my lord. Mother application. Mother intent. What is the nature of the suit property? Lordship, this is land. Bare land. Bare land along with some. What is your allegation with regard to violation? Lordship, kindly come to page 47. Page 47. The application, my lord. The বাদীর নিবেদন এই যে বাদী অত্র মোকদ্দমায় বিবাদীগণের বিরুদ্ধে অত্র আদালত। Yes. বাদীর নিবেদন এই যে বাদী অত্র মোকদ্দমায় বিবাদীগণের বিরুদ্ধে অত্র আদালতে ইনজাংশন ইত্যাদির প্রার্থনায় মোকদ্দমা দায়ের করিলে আদালত both the parties are directed to maintain status quo in respect of the nature, character and possession in respect of the property described in the schedule of the plaintiff. মর্মে ইনজাংশন আদেশ প্রদান করেন এবং অদ্যাবধি উক্ত আদেশ বলবৎ রহিয়াছে। উক্ত আদেশ সম্পর্কে বিবাদীগণের ফুল নলেজ রহিয়াছে এবং বিবাদীগণ জবাব দাখিল করিয়া উক্ত দেওয়ানি মোকদ্দমায় কন্টেস্ট করিতেছেন। অত্র মোকদ্দমা দাখিল করিবার সময় নালিশি ভূমির তৎকালীন অবস্থা সম্পর্কে আদালতের নজরে আনিবার জন্য ছায়েল তথা বাদীগণ আদালতে দেকাবি আইনের অর্ডার 39 রুল 7 and 151 ধারায় বিধান মতে দরখাস্ত করিলে উক্ত দরখাস্ত মঞ্জুর করেন এবং অ্যাডভোকেট কমিশনার হিসেবে অসীম সাই মহাশয়কে নালিশি ভূমির ইন্সপেকশন করিবার জন্য নিযুক্ত করেন। বাদীপক্ষ বিবাদী পক্ষ এবং উভয়গণের নিযুক্ত উকিলবাবুর উপস্থিতিতে অ্যাডভোকেট কমিশনার বাবু কমিশন কার্য সম্পন্ন করেন। কমিশনার উক্ত কমিশনের ফাইল রিপোর্ট আদালতে দাখিল করিয়াছেন। উক্ত কমিশন রিপোর্টে নালিশি ভূমির পশ্চিমে পি চিহ্নিত বাস্তুভূমির দক্ষিণে বন তুলসী বা গগন তুলসী বেড়ার বর্ণনা রইয়াছে এবং পি চিহ্নিত বাস্তুভূমির পূর্বে কিউ চিহ্নিত পুকুর থাকিবার বিষয়ে উল্লেখ আছে। অসীম সাই মহাশয়ের দাখিলীকৃত কমিশন রিপোর্টের ম্যাপ দেখিলে তা প্রমাণিত হবে। আদালতে সোলেম ইনজাংশন আদেশ সম্পর্কে সকল বিবাদীগণের প্রপার নলেজ থাকা সত্ত্বেও বিবাদী তথা সাক্ষীগণ আদালতের কোনো অনুমতি না লইয়া trial judge has directed the police to no, that was in respect of their application. Dismissing Chatterjee, what the police will go. His application, your application, Mr. Chatterjee, your allegation is that they are violating. Their allegation is that you are violating. Now the court directed what the police will go. Police will go and see whether the order of injunction has been violated. So it does not matter whether it's on your application, Mr. Chatterjee, whether it's on your application or on their application. Kindly clarify that. That no clarification is needed. Lordship, what will happen, Lordship? The police authority will, what is the real difficulty? Police authority is saying their application is allowed. So that means they will take steps against us. As our applications is dismissed, so they will not do anything. Lordship, kindly allow that this is a status quo order. Let the police say so. Bring to the notice of the learned trial judge with regard to that. Lordship, trial judge has not said that. Mr. Chatterjee, the order is directing the police to obey or to implement the order of status quo. That is the difficulty when an same thing they allowed their application. Status quo does not indicate anything. And in a bare land, Mr. Chatterjee, how the possession. Lordship, kindly hold that. Mr. Chatterjee, I'm asking you how the police will ascertain possession on a bare land. Then so, Lordship, I am in possession. An infractuous order, you are trying to implement. What is the problem? I am in possession. This trouble will come. You have invited this trouble. I am in possession. You prove that in a court of law. Can the police
commission report is there.
in a vacant land? In a vacant land, how will prove possession? By standing on the land.
There is a commission report.
Possession. Commission report says that you are in possession.
Kindly come to the commission report once, my
Commission report says you are in possession.
Lordship, kindly come. This is
Court has directed to implement the order, nothing remains.
Lordship, kindly come to only clarify, Lordship, that the order is the status quo in nature. So
Police
the
will
police
go and see
independently they will discharge.
that the police will decide.
Lordship, kindly hold that. Otherwise, Lordship, the practical difficulty I am facing.
This application under Article 227 of the Constitution of India is at the instance of the plaintiff praying for a direction upon the learned, is at the instance of the plaintiff and is directed against an order dated 11th of March 2025 passed by the learned Civil Judge Junior Division Kakdeep in title suit number 237 of 2023. By the order impugned, the application under section 151 of the Code of Civil Procedure filed by the defendant / opposite party herein praying for a direction upon the police authorities to implement the order of status quo dated 17th of October 2023 stood allowed. First a paragraph. Mr. Chatterjee, learned advocate appearing for the petitioner, submits that though the application filed by the defendants praying for police help for implementation of the order of status quo was allowed, but a similar application filed by the petitioner for such implementation stood rejected by the impugned order. First up, this court finds that the learned trial judge, by an order dated 17th of October
2025,
2023, passed an order of adding. What happened to the temporary injunction application?
It's pending, Lordship.
Pending. Addendum order can be implemented through police help.
That is the
Can be implemented through police help.
It's a question.
You are creating these problems. Addendum order through police, status quo order, vacant land, what the police will go. You are giving them the handle, they are using accordingly. It's you who are giving them the handle. They are using according to their wishes.
But this status quo order, sometimes, Lordship, they request because
It's a vague order, Mr. Chatterjee.
Supreme Court has also.
So, and that order you are trying to implement, giving us them the handle.
Yes. I agree.
You know? The passed an addendum order directing both the parties to maintain status quo in respect of nature, character, interest and possession over the schedule mentioned suit property for a limited period. First of Mr. Chatterjee, learned advocate, in his usual fairness submits that the application for injunction is still pending consideration before the learned trial judge. First up, however, the fact remains that the learned trial judge, by the order impugned, the learned trial judge, by the order impugned, directed the police, directed the officer in charge of Namkhana police station to maintain strict vigil so that both the parties abide by the order dated 17th of October 2023 in respect of injunction. First up, thus this court finds that the interest of the respective parties have been adequately safeguarded by the impugned order. First up, for such reason, this court is not inclined to interfere with the order impugned. First up, with the above observations, the CO number such and such stands disposed of.
You kindly observe.
I've said the interest
one
of
thing.
both the parties are being safeguarded.
Great.
Yes, next.
20. I'm for the petitioner in this matter. I'm for the petitioner.
Yes, yes.
But I have come against order dated 24th of April 2025, passed by the learned 4th Additional District Judge, Paschim Mednipur, rejecting my application for adducing evidence virtually, my lord.
Why?
My lord, I stay in USA. I have come last year 2 times. This year, my employer is not giving me a leave. That is one aspect. And
Video conferencing, it is very difficult.
my lord, I have complied with all the formalities, my lord, as framed by the Honorable High Court, my lord. I have sweared before the consular office there. I have stated the reasons. I have stated that I will pay all the costs which have been formulated by this Honorable High Court. Only on the reason that no consent was there of the other side of the respondent, this has been rejected. No, there's no.
Examination is very difficult through video conference.
My lord, only one thing, my lord. How the person can come every year? He will lose his job, my lord. He has come last year. He has come twice.
What is the next date?
Next,
I mean, direct the cross examination to be completed on that date itself, if not possible on successive dates. That much I can do.
My lord, on 37/20/25 is the next date.
Yes, I will direct that the cross examination to be completed on that date itself. If not on successive dates.
Now the cross examination, my cross examination is there.
Yes.
How will I come, my lord?
That is up to you.
My lord, the employer is not leaving me, my lord.
That is
So
you have to.
My lord, this honorable court has framed a rule, my lord. I'll show you. I have annexed the rule, my lord.
Yes.
It's at page 44, my lord.
What is the suit for?
So matrimonial suit, my lord.
Who has filed the suit?
The husband has filed the suit.
So you suffer the consequences if you do not.
My lord, the last year, 2024, I've come twice, my lord.
You do not face cross examination?
No, I want to face, my lord. I want to face. Your lordship will kindly come once, my lord, page 44.
Video conferencing cross examination is very difficult.
Your lordships have framed this rule, my lord. Your lordship will kindly come. 6. Any party to the proceeding or witness, save and except where proceedings are initiated at the instance of the court, may move a request for video conferencing. A party or a witness seeking a video conferencing proceeding shall do so by making a request in form prescribed in Schedule 2. Schedule 2 is the last page, my lord. I have complied with that. I have sweared it before the consular officer there in USA. I have stated the reasons. I have already undertaken that I will pay all the costs for the video conferencing. I have complied all the rules as framed by the Honorable High Court. So what is the legal? But there are provisions for holding video conferencing in the district court.
Give me a minute. No, your request was not supported by an affidavit.
Yes, my lord. That affidavit is before the consular officer, my lord. That I have done. I have annexed that, my lord. I have annexed that.
The consulate says that does not
How can
hold any responsibility.
Subject to correction, my lord. Can the consulate say? Can the notary public or the learned magistrate say? I ask this question to myself. I should not comment on this, my lord. Only because of the fact that the respondent has never consented, my petition has been rejected. There is no question of consent, my lord, if your lordship kindly comes to the rules, my lord. The rule says only discussion. I have discussed. I have.
Where is your application for video conference?
Yes, my lord. That is at page 56, my lord. I don't know whether it's paginated or not.
Yes.
Along with that, I have annexed that request form for video conference, along with the consular officer's document, my lord. Everything has been stated there. And I'm ready and willing to undertake all the costs for that. I stay, my lord, 13,000 kilometers away.
Have you produced any document to show that your employer has refused your prayer for this leave?
My lord, I have stated in our
Any
manual.
document that you have applied for and that was rejected? Because you have stated that likely the petitioner will not get leave till the end of the year 2025.
Lord, we have applied, my lord. If your lordship says, my lord, I shall produce that. They
You
will
have
not.
applied, but till now not rejected.
Sorry, my lord.
Till now not rejected.
No, they have said that you cannot get a leave because you have.
Where is that document? You have not produced that.
If your lordship
because
says, my
you
lord,
have-
I shall produce.
because paragraph 11 says would not get leave. Likely your petitioner will not get leave. So
Oh, that-
till that time of filing the application,
So that is
there was
the
no
petition.
decision of your employer.
I understand. That is the petition filed in the trial court, my lord.
Yes, yes. So till that time, there was no decision of your
But this is
employer
but
that your
this is a
prayer was
genuine-
rejected.
This is a genuine case, my lord. On the last year, my lord, I have
Saying it's
come
not
twice.
a genuine case,
Your
or a
lordship,
genuine
kindly
case,
visual-
but paragraph 11 says otherwise. You are saying
at
that
this point of time, losing a job, my lord, your lordship understands.
no, there is nothing on record to say so.
Normally,
You have
every
said
person are
unlikely,
reported, my lord.
likely will not get leave. That is your apprehension.
No, it's not.
Nothing from the
If your
employer.
lordship keeps, my lord, tomorrow, day after, I shall.
That not for that you will tell your employer, please reject my leave. He will reject.
No.
It's
I
not that.
I am on this.
Those
So because I am asking that I should
decide on
I
the basis of that application, not on any new document.
no, but it should be mainly basic. The basis should be the form.
What is the next date fixed?
36, my lord.
30th June.
Sorry, 37, my lord.
30th of July.
Yes.
By the order impugned, the application
For the petitioner, my lord, in this matter. Under this application number 227 on the Indian Constitution Act for expeditious hearing of the matter, my lord, the petitioner, my lord,
court is lying vacant.
my lord, the fact is, the petitioner is in.
Court is lying vacant. What can be done?
My lord, if you kindly direct the concern, the charge, the court who is in charge.
Court. This
My
application
lord,
under
on a particular date, the court was vacant. On a particular date, the court was vacant. Other than that, the court wasn't vacant. But the petitioner has a constant medical assistant, my lord. And the PW1, PW2 was concluded. The
charge court is there regular unless the regular presiding officer joins. It's difficult. This application under
Milord, 22, Milord, I'm appearing for the petitioner, Milord. This is, Milord, a classic case, Milord, where, Milord, the court has exceeded its jurisdiction. Lordship kindly sees since exceeded its jurisdiction.
What is the impugned order?
It's 2018, I tell you, Lordship, Milord, what has happened, Milord, period of 7 years, plaintiff is not appearing. Court is, Milord, intimating, directing and passing orders to the plaintiff, Milord, to intimate. Milord, plaintiff.
Defendant to intimate.
Not defendant, to the court, Milord, Milord, the department to intimate. Lordship.
The plaintiff, to intimate the plaintiff.
Yes, Lordship will be astonished, Milord, order number is specific. If the plaintiff doesn't appear, court has no other option but to dismiss. Lordship kindly sees 2018, Milord, the impugned order, Milord, I am coming later, Milord. Lordship kindly sees 15th of February 2018. Plaintiff didn't appear.
According to you, the suit ought to have been dismissed for default.
Dismissed, Milord. I filed another petition, Milord, for abandoned caution, Milord. I filed, Milord, although, Milord, there is no requirement for filing petition. Milord, I filed a petition, Milord, for dismissal. That petition has been turned down.
What is that order?
Milord, the last order, Lordship kindly sees, Milord, 5th of April 2025's order. Milord, my section 151 application has been turned down. And Milord, what direction has been passed, Lordship kindly sees. DA is directed to send letter to the plaintiff intimating him about the tracing of record and intimating the next step through the Nazareth department. Before that, Milord.
No. If the records are not traced, Mr. Chokko.
No, Milord. Records. Milord, I'll tell you, Lordship, Milord. There were at least 5 show cause notice was issued. Plaintiff didn't appear.
No, that is
since
for
2018.
Are the records available?
Yes, record not for on last occasion, Milord, record was not available. Lordship kindly see
the previous order.
Yes, Lordship kindly sees before that. Just before that, Milord. Milord, 18 January 2025.
So records were misplaced also on the previous day.
Yes, Milord, thereafter record came.
Record is misplaced. 2112. Records were not traceable, Mr. Chakraborty.
No. Lordship kindly sees before that, Milord. 22nd.
All right, so now the records have been traced. No.
Records traced already.
Untraceable for a long period of time.
Milord, it was not untraceable. Lordship kindly sees, Milord. I'll just show it to you, Lordship, Milord, the series of orders.
Chakraborty, I appreciate your submission that if the plaintiff does not appear, it is to be dismissed. But if the records are not traceable,
no, that juncture it was available. Lordship kindly sees 2018, Milord, the first order, Milord, I was just trying to show, Milord. Milord, 15th of February 2018, Milord, plaintiff didn't appear, Milord, show cause was issued. This is, Milord, the first order, first show cause. When, Milord, the ad interim prayer for extension was rejected.
That is there, but
Lordship kindly see no steps taken, Milord, just after that. Milord, it is a handwritten copy, Milord. No steps taken by the plaintiff, second show cause issued. Milord, just after that.
No, I follow that, but now
Milord, third show cause.
5th of April, Mr. Chakraborty, those are previous orders. Last order or last series of orders show that the records are not traceable. In the last order, it has been recorded. The records were missing for more than 5 years. And DA was instructed by this court to inform the learned advocate for the plaintiff.
No, Milord.
That records were, and plaintiff is absent without steps, that is also recorded. But the thing is that if the records are not traceable.
No, the record is absolutely traceable.
No, right. That is the order.
Milord, that is
then, Mr. Chakraborty, I can give you leave. You can file an application for that. The records, this is the finding. Records are not traceable.
No, Milord, Lordship, may I just, Milord, read, Milord, for once. Milord,
yes.
DA informed this court that the learned advocate on behalf of the plaintiff was informed, but the learned
previous paragraph.
Yes, on perusal of record, is seen that the record was missing for a period of more than 5 years.
Yes.
And DA was instructed by this court to inform the learned advocate on behalf of the plaintiff.
Yes.
Then DA informed this court that learned advocate on behalf of the plaintiff was informed, but the learned advocate mentioned that presently he has no contact with the plaintiff, so it will not be possible for him to inform the plaintiff.
Yes.
This opines that as the record was untraceable for a long period of time, was untraceable, that means now it is traceable.
No. Last paragraph.
So it will not be proper for this court to dismiss the instant case on ground of non-prosecution. Then, Milord, so the petition under section 151 filed today by the defendant number 2 is rejected at this stage for the ends of justice. DA is directed to send letter to plaintiff intimating him about the tracing of record. So, Milord, record
now has been traced out.
Yes.
That is why I am directing Mr. Chakraborty, 15th of September,
Is the next date
is the
fixed?
next date fixed, and directly if they do not appear, the plaintiff, the suit shall be dismissed.
Grateful, man. Lordship, may kindly peruse this order 9 rule 8 for a moment.
সব অ্যাভেলেবেল ছিল তখন 18 সাল ছিল তারপর 2020-তে কোভিড এর টাইম থেকে ছিল তার আগে তো করে
সেটা বলছেন লাস্ট 5 years বলা আছে।
This application under Article 227 of the
23. Lordship, I appeal for the petitioner. I pray for an adjournment for not this week, Lordship. I pray for not this week, Lordship.
Not this week. Why?
Lordship, the advocate on record is ill, and that's why she couldn't get a senior to brief the matter. So that's why, Lord.
On the prayer of the learned advocate for the petitioner.
My application against an order passed by the learned arbitrator, whereby the learned arbitrator is forcing my lord us to provide certain documents which we do not rely upon as a claimant. A very unusual set of facts, but my lord, I had to come before my lord because this is something unusual.
That is that.
My lord, kindly sees the impugned order at page 180.
180,
my lord. 18.
180.
Which volume?
A second volume, my lord. Take two. No.
No, 180 is the statement of defense.
Oh, certificate ko bhi করেছো? Oh, well, then my lord kindly takes 325, my lord.
325, yes.
করেছো, notes এ ভুলভাল লিখছো কেন তুমি? ওখানে নেই, ওখানে স্টেটমেন্ট অফ ক্লেম আছে। পিডিএফ আর কি? তুমি যা পিডিএফ দেখে নাকি?
Where is your claim application?
Statement of claim.
Yes.
Yes, kindly sees, my lord, the statement of claim. That's, my lord, at page 24. Lordship kindly comes. Lord, our my lord, claim relies, my lord, on a terms of settlement, my lord, entered upon in the year 2019. And that is the cause of action.
You are not relying upon this,
No, I am not.
loan come hypothecation agreement, fresh agreement. You are not relying upon any of these.
No, I am not, my lord, relying. Kindly takes my page 24. Kindly takes page 24, cost title of the claim, statement of claim. The terms of settlement dated 31st of March 2017. I am only relying on this. This is my case. Either as a plenty for claimant, I, my lord, succeed or I fail. Page 24, my cost title. The terms of settlement dated 31st of March 2007. This is my reference. I either succeed or I fail.
Fine. Back to him, the opposite party landlord. Landlord,
Yes.
decree has been challenged
You are
by
for the opposite party.
landlord.
Petitioner,
Judicial
Yes.
petition has been allowed.
Madam, my senior Kaushik is also.
Yes. Yes, Mr. Rai.
Madam, kindly see the improved order first.
Sir, please adjust your microphone.
First, kindly see the improved order. Madam.
Forty-seven has been allowed.
No,
208.
47 is pending. Second appeal also pending. 208 was allowed.
47 is also allowed.
No, no.
Oh, sorry, miss case number 47.
That is 208.
Sorry.
Pollution. Decree holder has already deposited police cost.
208 has been allowed.
Madam, kindly see, my lord, page 74, annexed D of your lordship's
What is the decree for?
ejectment. My lord, I have to give some time to fight.
You will fight in what
Second appeal
proceedings?
is pending. Madam, kindly see the
Second appeal, you obtain a stay in the second appeal.
I'll try to my level best, my lord. In the meantime, if I will evicted from the
Second appeal, it's pending in the order 41 stage.
yes, madam. Yes, madam.
It's in the list.
Not in the list, but I mentioned the
When have
matter.
you filed the before which court you have mentioned?
Court number 16.
When have you mentioned?
Well, before vacation.
Before vacation.
Yes, sir, go ahead.
When have you filed the second appeal?
Well, nothing has been done. Only filing.
Before
But
vacation.
when the second appeal was filed.
Well, that is not at that.
What is the number of the second appeal?
Second appeal number is কত জানো বলেছে কত বলেছে
Lord, considering the provisions of 2G, the decree was passed by the learned trial court.
Well, can my lord police SAT 11
or 2020.
24.
24. I'm keeping this matter next Friday week. Try your luck in the meantime.
But in the meantime, if my lord, I will evicted by the police, then all my lord, kindly see, my lord, once my lord, my objection of the police help petition. My lord, kindly see once.
Sir, I'm giving you 1 week's time to
2 weeks time.
No. 1 week is
2
sufficient.
weeks in the meantime.
Mention the matter today itself.
Today?
Yes.
Monday to কবে করে নেয় mentioning to Monday তে নেয় তো Monday I mentioned on Monday.
Monday. It's in the list. Have you checked up the list today? You have not checked up. So
it was in the list.
They are in the list today.
Okay.
So the notice of the copy.
You have not seen. You have not checked up the list.
No. হয়ে গেল নাকি
Next matter.
26.
On behalf of petitioner's advocate, Mr. Manoranjan Jana, his clerk is, he has not come today, Mr.
Yes,
Manoranjan Jana. Very painful not to come.
As prayed for by the learned advocate for the petition. Now on the prayer of the learned advocate.
No, I am for the petition. So an application is there, my lord, or section 5 application is there. Section 5 application is there, my lord. There is delay.
Please use the microphone.
There is delay. My lord, section 5 application is there, my lord. I have filed it. It is also on the list.
Yes, what is under challenge?
Challenge, my lord. The order of 2019.
2019?
My lord. Pass, my lord, missed case down, my lord. It was, my lord.
What is the miscellaneous appeal for?
It was told that, my lord, it was against, my lord, order passed in section 47 application. My lord, I was told that on learned advocate engaged in this honorable court to challenge the same misappeal or passed in misappeal. But, my lord, when the client, my lord, took steps, my lord, he came to, my lord, he heard that learned advocate died. So, my lord, he, my lord, went to the, my lord, learned trial court, and, my lord, knew that nothing has been done. Now the, my lord, execution has been, my lord, proceeded with, and, my lord, in this situation, my lord, I have filed this application, my lord, pretty long delay is there. If you lord,
it has been decreed.
Decreed.
Then
it was decreed. That
yes.
Their execution case was filed. Then 47 application was filed by the, my lord, defendant. Section 47.
Yes.
Then it was set aside. Execution case was set aside. Then the plaintiff left, my lord, miscellaneous appeal. In the miscellaneous appeal, the learned, my lord, trial court, my lord, first appellate court observed that my lord, remanded the matter to the trial court for further, my lord, proceedings. My lord, partly due to, my lord, lawyers, my lord, I am to say, my lord.
Yes. Now what happened?
Now what happened, Lord? Now happened, Lord. Practically the plots numbers are different. But
yes, now which order you are challenging?
I am order challenging, Lord, both the order in 2019 as well as
19 order.
As well
Nothing remains.
As well as
the execution has proceeded. This for
as of 2024. In which, my lord, I have been, my lord, directed to vacate the, my lord, premises, my lord, demolish the, my lord, building, because that is in another plot. My lord, I have filed another suit also. I have filed another suit. That is also pending.
Also obtain injunction.
So that is, injunction is there. In my suit, injunction is there, my lord.
All right.
My lord, what happened, my lord? If you, my lord, my lord.
Yes, move your application. Yes.
My lord.
Move your application.
My lord.
What is the ground of your challenge here?
My lord, ground challenge, my lord. The suit filed by the, my lord, plaintiff in the, my lord, plot number 1124. Actually, I am the owner of 1124 by Bata plot. But they have my lord, made me party and, my lord, tried demolition of my building on that plot. I am the owner of, my lord, 6 decimals. They are on another part. They have paid for partition as well as there is no partition is there, my lord, no investigation commissioner is there, nothing is there. My lord, should have been decreed ex parte. And, my lord, thereafter they moved, my lord, execution case, and I filed application under 47, and 47 order was passed in my favor. They challenged the same in misappeal. In this situation, in misappeal, my lord, remand to the matter. My lord, practically my lord, difficulty the learned advocate, my lord, I engaged him.
All right, I appreciate that. Now come to the merits of this.
Merits of this case, my lord, my lord, the plot numbers, my lord, are different. I have preferred another suit also.
Yes, show me the infirmity in the impugned order.
Impugned order has been passed, my lord, on the plot number 1124.
Show me, place the impugned order. Where is the infirmity?
Page 25 is the, my lord, schedule of the plaint.
Page 25?
The schedule of the plaint.
Yes.
There is, my lord, cause schedule. Original,
Yes.
my lord, bottom plot number 1124.
Yes.
Actually, the order has been passed, my lord.
Where is the decree?
Decree, my lord, page 32 is the order, my lord, decree is the 33. But type decree, my lord, 33. Decree has been, my lord, it has been decree ex parte.
Expertise degree is also a decree.
No, my lord, I am.
You have not challenged that.
My lord, there, my lord, there is no information was there. So, my lord, they moved, my lord, my lord, execution case.
Yes.
I filed application under 47.
Yes.
Thereafter, my lord, 47 I own. That was the charge.
Where is the order passed under section 47?
47, my lord, page 45. Actually, then my lord, list the records of right 51. My plot number, that is, my lord, 1124 by 1591. That is Bata plot. But they are claiming, my lord, yes, my lord, main plot 1124. This is the difference. My lord, they are without, my lord, proper observation, without, my lord, proper application of mind. My plot, they have claimed demolition of, my lord, my building and possession over the said plot. So I have filed another application, my lord, title suit that is pending with interim order.
Where is the copy of the judgment?
Judgment, my lord, judgment, my lord, actually typed copy, my lord. My kindly see judgment, my lord, page 30. In lawsuit, plot number 1124.
Yes, now where is the order directing the delivery of possession?
My lord, my lord, kindly see, lord, page, lord, last page, lord. There are notice.
He is out of town for his personal reason, for his daughter admission. So kindly praying for not today.
Not today, next.
29.
Hmm.
29 वाला I'm for the petition. Petition is the one dependent one वाला. Plaintiff filer partition suit. Well, I am the defendant number one in the suit. Well, initially, he moved an application for injunction that was refused. Well, and Miss Appeal was prepared. Well, without disclosing, the injunction was moved. That was refused. Suppressing entire material facts. Before that, there was a previous litigation between the parties. Where plaintiff father was the plaintiff father was the plaintiff, and defendant number 1, 2, 3 is the plaintiff, was joint plaintiff.
You apply before the appellate court, apply for vacating. That is better. Otherwise, here it cannot be stayed. It will be kept pending here unnecessarily. I am giving you liberty to apply for vacating. Or if you want, I can direct the miscellaneous appeal to be disposed of. If you enter appearance, I can direct the miscellaneous both ways, whichever way you want. Because injunction order cannot be stayed. That is the difficulty.
My construction has been stopped.
So you are the only party.
No. Well, there are several parties, my lord. The injunction has been only for against me, my lord. That's why, my lord.
Injunction is only against you.
Yes, my lord.
So you are the affected party.
My lord, the previous lavender litigation, this honorable court, my lord, granted leave to, my lord, all
Right,
the
so
parties.
you are the only party, so I can direct you to file you file an objection to this. I will direct the miscellaneous appeal to be disposed of
Within
expeditious.
certain,
This application.
The petitioner filed an application under Order 1 Rel 10-2 that has been rejected, which is impugned before your lordship.
Order 1 Rule 10-2. What is the suit for?
Suit for recovery of possession from the trespasser. What happened?
Suit for recovery of you are the plaintiff.
No, I'm filed an application under Order 10-2 for adding himself as a party.
Why?
Well, why I'm saying that? What happened was the plaintiff of the suit.
Plaintiff does not want recovery of possession from you, and you want yourself to be impugned.
Yes, that is my case. That is my case. If you
What is your case?
Can you see the impugned order? Kindly see first, second, third, fourth. Paragraph starts with the plaintiff. The plaintiff, by filing written objection, has claimed that the petitioner is trying to illegally encumber the property.
Which paragraph?
First, second, fourth paragraph, my lord.
It starts with plaintiff has further stated.
By filing written objection.
Yes.
Has claimed that the petitioner is trying to illegally encumber the property of the plaintiff by giving possession illegally to strangers, despite having no right of ownership in the suit property. Upon considering the submission by both the sides, it appears that the petitioner admittedly has no right of ownership in the suit property. Moreover, in the instant suit, the plaintiff have made claims of trespass against Momnath Joshi,
who appears to have obtained possession from the petitioner, that is me, Molay Kumar Kundu, who admit of having no right of ownership in the suit property. I therefore, as per the established principle of law, a person who has no right of ownership in respect of any property is not entitled to create any right or interest in such property in favor of any person. But what happened, my lord, I am a developer. I am a developer. I constructed a building by an agreement. The said agreement was challenged by the plaintiff in a suit. The said suit was dismissed. They preferred.
Sir, Ghosh, can you compel if you have your remedies against the plaintiff, you file
I filed a suit. The suit is pending.
So,
no, but what happened?
Nothing remains. Mr. Ghosh, can you compel the plaintiff to proceed against you?
No, but kindly consider
Plaintiff is the Mr. Ghosh, plaintiff is the dominus litis.
Yes,
he
yes.
can choose against whom he wants to proceed against.
He is filing a collusive suit to establish
Mr. Ghosh, that decree will not be binding upon you. That decree will not be binding upon you if you are not a party. Why are you trying yourself to get implemented?
If he got a decree, tomorrow he will come with a decree and he will get the position. And they will say that I am in position. The plaintiff will say I am in position.
Ghosh, that decree will not bind you.
Yes, that's my. And you have it will affected me, my lord. It will affect me.
If any of your rights are being affected by the plaintiff, you have to file a suit against the plaintiff.
Well, I've already filed a suit in
You cannot complain the plaintiff, please proceed against me. Where is the law?
I've already filed a suit for
proceed. Nobody is stopping you.
For basic performance.
Nobody is stopping you from that.
The plaintiff filed a suit that
filed a suit for trespasser against a third party. Let him proceed against him. But that decree cannot bind you because you are not a party.
That's true, Malta.
So
it will not binds me. But the situation is that he will get the position by a court order, and I have really taken exception to that.
This application under Article 227 of the Constitution of India is at the instance
lordships kind leave, my lords.
But
I
31 and 32 are the same. So
31, 32 same.
three suits are the other suits.
31 suit numbers are different.
Suit numbers are different.
So 31, 32 same order, reasoning same. শুধু ওই উপরের পার্টটা
Number
দেখে
is- And the defending opposite party number.
Lords, item number 44, my lords, is appearing, my lords, upon mentioning, my lords. Lords, tomorrow is the date for final hearing before DRAT, my lords. Lords, my lords, was pleased to take up this matter, my lords, day before yesterday, when the opposite parties appeared, we have served copy and everything. If this matter is not taken up today, my lords, we will be in a difficult position tomorrow, my lords, before the 44, my lords. 45.
Yeah, but
Let 44 of today's list. Let me see how far I can proceed.
My lords, if I was humbly praying, if any time.
Not come at 4.
I am grateful, my lords.
Yes.
2 PM matters 49.
My lord, I appear for the petitioner, my lord. My lord, this is arising out of a proceeding before the, my lord, now presently pending before the State Commission. My immediate grievance is this, my lord, because of an order passed by the State Commission, passed by the, my lord, District Forum, against which I have challenged by filing a revision petition before the State Commission, which is not being taken up in the absence of quorum. I am suffering. Effect of the order is, my lord, in the complaint case,
State Commission, there is no quorum.
there is single member, there is no effective hearing for, my lord, consideration of a prayer for stay. The order of which I am seeking stay is an order of 3rd of September. By reason of that order, what has been done is, my lord, my right to, my lord, recover, my lord, arrears on account of, my lord, tariff has been curtailed, and this is a blanket stay which has got by an executing court which has got nothing to do with, my lord, the main proceeding. The complaint proceeding before the, my lord, forum, this had a checkered history. My lord, 3 rounds of, my lord, from the District Forum to the
What is
State
the
Commission to
interim
the
protection you want?
I want, my lord, stay of the order. That is the interim protection I seek. My lord, first kindly comes to the order, kindly.
What order? Please show me.
Kindly comes to page 124. My lord, this is an order of 3rd September 2024. My lord, at 125, I will just read it, place it for your lordship.
125, yes.
Having heard both sides and considering the surrounding facts and circumstances as appearing from the materials on record, as well as the stage of the pending proceedings pending before the Honorable Circuit Bench Asansol, SCDRC and the Honorable High Court Calcutta, we are of the opinion that it would be just and proper to adjourn further proceedings of this execution case for 60 days as prayed for by the judgment debtor. So as to, we are also of the opinion that it would be just and proper to pass an order of injunction restraining the judgment.
124.
My lord, at 125 I was placing, my lord.
Yes.
The second paragraph, my lord, having
paragraph, yes.
May I start again, my lord?
Yes.
Having heard both sides and considering the surrounding facts and circumstances as appear from the materials on record, as well as the stage of the pending proceedings pending before the Honorable Circuit Bench such and such and Honorable High Court at Calcutta, we are of the opinion that it would be just and proper to adjourn further proceedings of this execution case for 60 days as prayed for by the judgment debtor. So as to, we are also of the opinion that it would be just and proper to pass an order of injunction restraining judgment debtor not to disconnect electric connection of the decree holder factory by the strength of the notice dated 26th August 2024 or by issuing any other notice of disconnection till disposal of the EA case.
What happened to this EA?
My lord, the EA is pending. The execution case is pending. The execution case is arising out of an order passed in favor of the complainant in terms whereof the complainant is entitled to certain damages. My lord, these damages pertain to, my lord, a period from 2006 onwards. My lord, the issue was
there is a revision pending.
Against the no revision is pending. No revision is pending.
So if the execution application is disposed of, I think that will be.
No, my lord, today by reason of the 3rd September order, my lord, there is a tariff order. My lord, kindly seize that 24th August notice.
But by this, you are agreed by this because there was an order restraining disconnection till the disposal of the execution application. I am directing the execution application to be disposed of.
My lord, the forum, if the quorum is not there before the State Commission, I continue to suffer, my lord.
No, execution is before the district forum, not the State Commission.
Yes, district
forum has the quorum.
My lord, if it is in a
this order was stay was for a limited period till the disposal of the EA case. Let the EA case be disposed of within a certain time.
But this order continues, my lord, till such time the EA case. My lord,
how much time it will take?
My challenge is
how much time it will take.
My lord, it's difficult, my lord. It's difficult, my lord. My lord, kindly visualizes the situation. 3rd September.
Otherwise, if during the pendency of that, this order is vacated.
No, question is, can this order be passed at all?
Becomes infructuous.
No, it won't.
My lord, if it is an order wholly without jurisdiction and the executing court does not have jurisdiction under the sun to pass any order, any blanket order, executing court will only see I am executing
At
the
that
order.
point in the execution application, get the execution application
My lord,
dismissed.
from September 24, today we are in June 25. My lord, I have been suffering, I have challenged
What is
it
the next
before
date fix? Take out your preliminary objection on that, on the maintainability, get the execution application disposed of on that date itself.
My lord, two things.
So that you are
Maintainability,
saying that it is not
maintainability,
maintainable?
no, execution, I cannot say execution is not maintainable. What I am saying is that the order which has been passed by the executing court today, which is bothering me, that is, my lord, without jurisdiction. I challenge that order before the state commission.
This is an interim protection till the disposal of the main proceed of the
I am trying to, my lord, persuade your lordship to test whether this interim protection can be continued.
That has to remain, otherwise the execution application will become
No, my lord, it won't. My lord, kindly bears with me for 5 minutes. My lord, I will want
also, I am directing the execution application to be disposed of
my lord,
in a
that
time bound
will,
manner.
that will not really, my lord, serve my purpose. That is basically rejecting my petition. My petition which has not been heard by the state commission because I don't have a quorum and I don't get an order from your lordship.
Order you have challenged before the state commission.
Yes, and there is an application.
So this order you are challenged before the state commission due to lack of quorum, you have applied under 227.
Correct.
So the order basically says that passing an interim order till the disposal of the execution.
Only lordship sees whether this order could have been passed by the executing court considering the final relief that has been afforded to the complainant by the district forum. If lordship feels yes, this is an order, then lordship
the final relief granted.
Kindly comes to my lord. Page 58. That is the final order of the district forum.
Is this matter, Mr. Kaur, Mr. Dotto, I think some batch of appeals were being heard before the Honorable Division Bench.
It is, but it has got
Any
no
issues
connection.
are related because I was a part of that division bench. Would it be proper for me to take up? I do not know whether the issues are same or not.
If lordship hears me for 5 minutes, lordship will realize it is not
Because
connected.
both of you know on facts. That is why I am asking both of you.
That this has got no connectivity with that division bench.
So then there is no difficulty.
No
All right.
No
That is what I was trying.
I am very grateful, my lord, to Mr. Kaur. My lord, kindly comes to my lord, page 58. Page 58 is the final order by the commission, the district forum. I want to show your lordship the relevant portion as to what was the issue which has been adjudicated upon. Kindly comes to page 63. My lord has got that 63, my lord.
Yes.
Third paragraph. Third paragraph. Having heard.
Yes.
Having heard the arguments advanced by the learned advocates by both sides and considering the contents of the petition of complaint, written version thereof filed by the OPs in the earlier occasion, written notes such and such, previously as well as presently by the documents and papers produced by both sides, it appears to this commission that the complainant has filed this case on the allegation against the OP, that is my client OP, that after October 2006, one Purulia Metal set up their factory adjacent to the existing factory of the complainant.
So, Doctor, you calmly come to page 65. So
The
that is
operative part.
yes.
Operative part. Very well.
So that was put into execution.
Very well. Operative part is, my lord, first part is, my lord, damages, a claim of 46 lakhs 62,532.
was put into execution.
No, there is one more part because I am sure, my lord, this would be shown by Mr. Kaur. Kindly comes to the second paragraph of that case. Lordship will find the last line. The opposite parties are restrained from disconnecting the supply of electricity to the factory of the complainant until proper adjustment of the adverse effect of harmonic flow of electricity, or for the matter removing the harmonic flow of power supply by any means.
Yes.
So this was, my lord, the cause of action in the complaint was inflated billing. My lord, so far as this consumer was concerned, so he gets, my lord, damages for a particular period and another chunk of damages as by way of compensation and an injunction that I won't disconnect electricity till such this issue is decided. Now in 2018,
this order has been challenged where?
Now this order, I have challenged this before the, my lord, state commission.
In the revision application.
In a, my lord, revision, my lord. No, first, my lord, in an appeal. This was preferred in an appeal. Now, what the appellate court did, the state commission did, there was a delay condonation application. The state commission, my lord, passed an interim order of stay without first condoning the delay. Naturally, there was a challenge
of looking at it. So, one is what you are trying to submit that
I suffered.
Unless the delay is condoned.
Interim order.
But there are one or two decisions also. Under exceptional circumstances, if the situation so demands that it cannot wait. So in that cases,
today it
will
late in the
without
day.
condoning the delay
Yes,
taken,
Lordship
because
is absolutely
there are
correct.
two ways of looking at it, two line of
My lord,
seekers
extreme
also.
urgency, my lord. Yes, courts have, my lord, given protection, my lord, even pending, my lord, condonation.
Yes. So now
My lord, what had happened? That order of stay, which was granted by the
Mr.
State
Doctor,
Commission.
this order is
My
under
lord,
challenge at
my lord, 5 more minutes, my lord, kindly.
Yes.
That order of stay by this granted by the State Commission was challenged by Mr. Kaur's client in a 227. Coordinate bench said, no, this is prima facie wrong. So the state, my lord, High Court stayed the, my lord, appeal which I had preferred. High Court did not stay the order. The language in the order is, I am staying all further proceedings in the State Commission appeal.
So the appeal will not proceed.
So the appeal will not proceed. Now this order of the High Court is also not extended subsequently. There is an application pending.
So the appeal now can proceed.
So the appeal can also proceed, but I don't have a quorum to proceed. This order of 3rd of September, which I showed to your lordship, is now, my lord, bothering me because in the meantime, what had happened, there was, my lord, a tariff order for the control period 2017-18. My lord, initially, before the APTEL, which is the appellate authority.
Doctor, those are on merits.
No,
then
no,
have to
no.
fix it because
My
there
lord,
are other.
my lord, my lord, kindly 2 more minutes, uninterrupted 2 more minutes, and then lordship will realize what I am trying to, my lord, persuade. My lord, APTEL indicated initially that there would be a blanket stay. Even if you are not before the appellate forum, if you are a consumer, you will be benefited by the order. Subsequently, APTEL clarified it would be only for those persons who are before the APTEL. Now, after that, there is a, my lord, order, tariff order for the control period 17-18, in view whereof, my lord, I am entitled to recover arrears from this consumer, even others, all consumers. I, my lord, cannot today recover this arrear which has got nothing to do with the complaint case. This has got nothing to do with the complaint case because of the, my lord, order passed by the 3rd September.
This is connected to the division.
Yes.
This is
That is why
This has got nothing to do with, my lord, complaint case. Nothing to do with the complaint case.
Yes.
Can the, my lord, executing court, my lord, restrain me? My lord, I could have understood, my lord, they, after filing this, my lord, they went to a writ court also. Writ court did not give them any protection.
So, Mr. Doctor, if you let us assume that you are permitted to realize this.
Yes.
And there is no stay, what remains in the appeal?
My lord, appeal is mine.
Yes.
Appeal is mine. I am not prevented under the district forum order from, my lord, doing any action which is subsequent, which was not even perceived by district forum when district forum had passed the order. Today, by reason of this order, my lord, I am being restrained from doing something which was not there when the district forum passed the order. So naturally, district forum could not have perceived that this kind of an restraint order, the executing court.
Two things: I can direct the district forum to dispose of the execution application in a time-bound manner, or if you want,
which would mean, my lord, which would mean
I will hear you both on merits. I will fix another day.
Lordship,
so in this way, it cannot be a state for
state forum here in Calcutta is functioning. The matter can be shifted here. There is no difficulty.
Shifting.
No, my lord, whether that is permissible.
Because that's the circuit bench. That's the circuit bench.
So
this is the main bench.
This is for where?
This is Lord Purulia. Asansol is the circuit bench of the State Commission.
Yes.
So main State Commission is in Calcutta. Circuit bench is not in operation. It's not that the main bench is not operating. Main bench is there. That matter can easily be brought. If he mentions before the chairman here, he will get this matter and have the matter
done, Mr. Doctor.
Well, two things. And first, the command which lordship gave me that I will direct the executing court to execute it within a time-bound manner. This is for me, my lord, with deepest of respect, a non-starter, which means my appeal is gone. I am going to the executing court with a time-bound order from this court that please execute the order, the same order which I have challenged. So that is not possible for me. My lord, the second thing, my lord, whether I have, my lord, a recourse available, I can avail of that, my lord, I can try that.
So, Doctor, you are challenged, according to you, there is no quorum for which you cannot proceed with your appeal.
So I seek some protection from your lordship. This order is staring at me and is troubling me every day, my lord. Under the sun, blanket order given by the district, by the executing court, which has restrained me.
You want your appeal to be disposed of before the state commission?
Yes.
So apply for transfer of that?
My lord, I don't have a quorum before the state commission. I have a
commission. Mr. Kaur says That is in the that is the circuit bench. If before the principal bench, I can adjourn this matter. You try your luck for transfer. I'm keeping this matter pending.
I need something, my lord, kindly considers. Current dues have to be paid. He cannot, my lord, enjoy electricity, my lord.
Current dues have
This,
to be
my lord,
paid.
order is preventing me from taking any coercive action.
Current dues have to be paid. Areas, so far as areas, you have to pay the current dues. Current dues.
My lord, I have a right under the act to, my lord.
being paid. Current dues are being paid.
My lord, arrear and current dues have to be paid. I have a right to, my lord, disconnect otherwise.
Mr. Dotto, you said current dues.
No, my lord, current
Dues they are paying.
current as well as arrear.
The areas, I can do one thing. You try, you want. The basic thing is that you have to get your appeal decided. You started with the submission.
Revision,
Sorry, not the appeal, the revision decided. So you started with the submission that you don't have any forum.
That is why I wanted some
Due to lack
protection
of
from
quorum.
Yes.
So if that is transferred to the principal bench here, so your remedy.
My lord directs that today. My lord directs that today, my lord, they will be bound by lordship's order.
You approach the tribunal, I'm adjourning this
Again.
matter. I'm adjourning this matter for 2 weeks.
But if supposing the circuit bench is not functioning, your lordships always take up the matter here.
I think that's the principal bench will be in a better position to transmit instead of
But so
under
far as my
57
my lord, how will this order today, whatever order lordship is, my lord, perceiving, how will this be looked upon?
I'm not
as if
no, I'm not passing any orders today. I will be only adjourning for 2 weeks to enable you to take steps.
Right.
I will only record your submissions.
and
There is
in
no
the
forum.
and in the event, my lord, I don't succeed to have this transferred in 2 weeks. Kindly, my lord, makes it clear that lordship will consider this issue.
I'm only adjourning. I'm not saying anything. I'm only adjourning, giving you liberty to approach the chairman of the state commission for transfer.
This is a
Since I will record your submission that due to lack of quorum, you cannot move your revision application.
Very well, lordship provides for that. And I'm sure, my lord, the words used would be, my lord, good enough for me to get an order of transfer there. I'm sure about that. My lord, then my lord, lordship will also provide that the entire appeal and the revision which is pending both can be transferred. Appeal and the revision.
Yes, appeal and revision.
Yes, appeal from the plain order.
That is what I wanted to place. Lord, what
So
happened?
both can be transferred.
Both can be transferred.
That let him they make
Yes,
that
yes.
application. Let the
And
chairman
keep it
decide.
after 2 weeks, my lord, I'll apprise your lordship.
Let the chairman decide.
So give me the.
I'll give your lordship the
give
2
me
numbers.
particulars.
Yes, I'll give your lordship the 2 numbers. My lord, the appeal number is lordship will find at page 66.
Please wait, I will ask you, please then furnish the number.
Page 66, my lord.
Challenging
अच्छा, लिख
the order
कागज लिख
dated
145, I am for the petitioner.
Yes.
Mr. Mahato appearing for the opposite party.
Yes.
Mr. Rabindranath Mahato.
Is for the caveator.
Yes, for the caveator. Just now, yes. Here, my lord.
Yes, what is this matter?
Matter, my lord. The plaintiff filed a suit for declaration and injunction.
What is the impugned order?
Declaration for, my lord, the petitioner plaintiff, the half share of the A schedule property and B schedule property gifted is illegal and null and void. During pendency of the suit, my lord, the PW1 filed an application for more witnesses. That was, my lord, witnesses. That was, my lord, after 2 days, my lord, that was
Medical officer, why?
Medical officer, my lord, the gift deed was executed by the deceased in favor of the defendant at old age time when he was, my lord.
So your evidence was closed.
Yes, my lord.
Yes, Mr. Mahato, what do you say? Evidence closed, let them.
Evidence was closed, but it is very simple thing that evidence is closed. But when it has been, my lord, when the summon was issued, April 2024.
Yes.
30th April 2024, my lord, the summon was issued. The next date was fixed, my lord, on 25th of July 2024 for PW2.
What is the next date fixed?
DW1.
What is the next date fixed for DW1?
My lord, next date is.
So if on that date, the they can present the medical officer, let the evidence of the medical officer be done on that.
Kindly consider one thing. They have not filed any document to prove by the medical officer.
But that
What
was,
will be proved?
Mr. Mahato, that order was there. Liberty was granted for the evidence. That was there. Only that was closed because on that date, the medical officer was not present. I'm giving them an appointment. What is the next date fixed? Your evidence has not started.
No, no.
Your evidence has not started.
So,
how many witnesses of the plaintiffs were done?
Only 2 witnesses.
This is the second witness.
Second witness.
PW1 closed. So PW2.
PW2.
So I'm directing.
My lord, I have filed an application before the court below to summon the medical officer. Well, kindly see page 43.
What happened to that?
Well, he has received not come.
Then what can be done?
My lord, one thing, my lord.
Where is that application?
Application, my lord. Page 43.
43 and
43 and 46.
On 25th of July, they did not take any step. They did not appear before the court.
Here, when he was
43. So 46.
46.
43 and 46. No date.
The landed court bill ought to have applied the order 16 rule 10, my lord, to bring in the witnesses.
On the basis of this application, my lord,
order 16
someone
rule
was
10,
issued.
kindly see, my lord. Where a person to whom a summon has been issued either or attend to give evidence or produce or a document fails to attend the procedure and documents compliance with the summons the court. What is that mean?
That will be done. How that will help you?
Yes, my lord. Well, kindly see, my lord. A, B, and 2, my lord. Where the court sees reason to believe that such evidence or procedure is materials and such person has to, without lawful excuse, they fail to attend and produce the documents and compliance with such someone has been intentionally avoid the service. I have made twice service, my lord. It's a very vital witness.
(2019) document.
What is the suit for? What is the
declaration?
Why do you want this medical officer to come? What happened?
What happened, my lord? My second, my lord, the decree, the second schedule property, B schedule property, the gift deed is null and illegal, void and illegal.
Yes.
Yes.
What the medical officer will do?
My lord, when the disease admitted in the hospital, you have treated him. Whether conscious minded or unconscious minded, the gift deed was may execute in favor of the.
What is your statement with regard to that?
My lord, kindly see on the plane I have annexed.
Was that summons issued?
Yes.
Served upon him?
Yes.
Issued.
Yes.
It was issued, my lord, by order dated 30th of April
My lord,
2024.
I have annexed page 44. Page 44. Daily item delivered to the sender.
What can be done if that medical officer does not come? Nobody knows whether that medical officer is still available or
Landed
not.
court below ought to have, my lord, take steps to bringing this out. Otherwise, I can, my lord, to come, I can not, my lord,
What you will do? What you will do?
it is very necessary for this.
If he does not come,
Kindly keep him, fix a 1 day time to 2 days time. If he is not come, that videos will be closed.
My lord, kindly consider. The medical officer will come and give evidence on what basis, on what document. What document?
he has not produced any medical papers,
No,
nothing.
nothing. My lord, this is the application section. My lord, page 43. Page 43 is the only
That is your
application.
application for exam.
Page 43.
Page 43.
দরখাস্ত তরফ বাদীর পক্ষে নিবেদন এই যে উক্ত নম্বর মোকদ্দমা প্রমাণের জন্য নিম্নলিখিত ব্যক্তিকে মহামান্য ও তলব করা একান্ত আবশ্যক হইতেছে নতুবা অধীনের অপরিণীয় ক্ষতি অথবা দরখাস্তের প্রার্থনা সাজেন সাজ. This is the first application
medical
and
officer.
second application is at page 46. Man,
Is
what
this
is
person living with him, my lord? When he alive, my lord, when he alive,
on what document he is
you are-
relying
you
upon?
are- you are in custody, their
Nothing
custody.
has been disclosed.
So how I collect the medical report from the
So
hospital?
deed of gift was executed by whom?
By the petitioner number 1 father.
Your father?
Yes, petitioner number 1 father.
You are petitioner number?
Petitioner plaintiff, petitioner number 1. Or petitioner number 2 and 3, the
Yes.
son of the wife and daughter. He is the one of the son.
So your father executed the deed of gift?
Our father give in favor of the grandson.
Yes.
Grandson. The
So-
grandson kept him in custody when he was ill, by manufacture, by fraudulently executed gift deed.
Doctor examination, my lord,
Is very much less
irrelevant.
like
Government hospital?
Government hospital.
So why did you not text us for bringing those medical documents?
My lord, kindly, my lord, one thing, my lord,
Yes, yes.
kindly one day's time.
No,
I
no,
can
no.
bring it.
This application under Article 227 of the
2022.
All right. Item number 11. Miss, acha, this it is item number
1147.
item number 1147 of the monthly list. This matter is taken up upon being mentioned by Mr. Mahato Learned Advocate appearing for the petitioner citing urgency. First up, the opposite party is represented by the Learned Advocate. First up, this CO হচ্ছে 702 of 2025 এটা ঠিক আছে this application under article 227 of the Constitution of India is at the instance of the defendants praying for a direction upon the learned civil judge junior division at Kharagpur district Paschim Medinipur to dispose of title suit number 34 of 2022 expeditiously. First up, from the order sheets appended to this application, this court finds that 19th of December, 19th of February 2025 was fixed for evidence of the defendant's witness number 1. What is the next date fixed?
Next date,
Full stop.
7th March was the last. Then I don't know.
Full stop. Paragraph. In view thereof, CO number 702 of 2025 stands disposed of by
Given liberty to my lord.
you are entitled to as per the law, no liberty is necessary. Yes, call the list.
May it please your lordship, Milord, I appeal for the petitioner, Milord, led by Mr. Probal Mukherjee.
Which item?
136.
136.
My lord, kindly, my lord, direct my lord's court officer to my lord enable my video. It is my lord the.
Mr. Mukherjee, video to enable to.
Yes, yes, he is visible.
Mr. Mukherjee is not physically visible in court.
Lord,
Has become Milord UK national, I am told. Half UK.
Lord, I'll be there next week, Lord. I'll be returning on Lord.
Yes.
On Saturday.
Yes, yes. You are opposing.
My lord,
There is no
this matter, Lord.
Mr. Mukherjee, let me hear because yes.
My lord, we have not filed any caveat, but we have the vokalatnama of the sole defendant, my lord. That is the since we have
the urgency.
But I'll just not indicate what has happened. Lord,
no, we are
Stop
not
the
making
construction.
No, my lord. This was an application.
All right, let me see. You have not lodged the caveat. Yes, let me see. Yes.
Yes.
Yes, Mr.
but I'll
Mukherjee.
just indicate, Lord, in short, what has happened. Lord, I am a widow lady with 2 children residing at the property, Lord, which was, Lord, my husband's, Lord, inherited property. Now, Lord, I was residing in part of that property, which is not more particularized in the schedule. Now, Lord, on 20th of Lord, October 2024, I alleged that my brother-in-law and his son, Lord, they have put a padlock in Lord, the portion where I resided. I lodged a police complaint. Thereafter, Lord, within Lord, the statutory period, even 1 month earlier, Lord, I have filed, within 1 month, I mean to say, I filed a Section 6 application. The Section 6 application was turned down by the learned judge, saying that when I have filed, Lord, the electricity bill, it was shown that for the previous 2 months, the reading was 0. Therefore, the learned judge is of the opinion that I was not possessing the property. Although the learned judge in the order has recorded that the death certificate of my husband, the birth certificate of my children, stands in the name of my lord the suit property. Now, my lord, after my lord the Section 6 application was dismissed, I was constrained to take out a 115 application before the learned district judge. Before the learned district judge in the civil revision application, my lord, at page 70, your lordship will find that I have vented out why, my lord, I wanted an ad interim order of injunction, because even from the photographs appended to my lord's brief, your lordship will find that after my lord dispossessing my client, my lord, they are attempting change of my lord the suit property. So, my lord, we have stated that in our revisional application. We have appended photograph to show that there is an attempt in changing the property, and we asked for my lord an interim order before the revisional court. The revisional court admitted my lord the revision application, posted it for hearing after notice, but refused to pass my lord any interim order. As against that, I am before your lordship.
So now you want an injunction not to change the nature and character
So
of the...
at the moment, my lord, I want it. And if my learned friend lord comes up, lord, then your lordship may kindly hear the matter on merits, because I'll be only on that point when the learned judge says that, lord, the reading is 0, whether it can be, lord, imputed that I was not residing in the property.
That is, Mr. Mukherjee, that is on merits, but when you are dispossessed.
Lord, 20th of October 2024, and I filed, lord, the suit on 11th of November 2024.
20th of October 2024 is the date of dispossession.
Lordship.
And when the suit was filed?
11th November 2024.
11th of November 2024.
Within a month?
Yes.
So it's within the period of limitation?
Yes, but it is with the limitation is not an issue here. I just wanted to say that I was very prompt in complaining before the court about my dispossession. I also lodged a police complaint. But the learned judge, lord, whilst not dismissing my application, your lordship will kindly see internal page 17 of the impugned order of the trial court. Not only says that, my lord, the reading in, my lord, the electricity bills that I have filed shows, my lord, the consumption is 0. 55. That led to a presumption that my client was not residing there.
Mr. Mukherjee, where is the order passed by the trial court?
Lord, your lordship will find internal page 17, running page 172, the relevant, my lord, the portion. Internal page 17, running page 172. I'm just placing before your lordship the relevant, my lord, the learned judge's consideration.
Wow. The detailed order, Mr. Mukherjee, it's
yes, but my lord, the learned judge has discussed about my case, my lord, the defendant's case, and my lord, I'm only taking your lordship to the finding why the learned judge has said. Lord, page 17.
Finding is that you have not been able to prove your possession.
Lord, this is exactly, Lord, what I'll like to address your lordship. Why I say this, Lord, if your lordship kindly comes to page 17,
so
Lord, about, Lord, 4th line from top.
Which page?
Lord, internal page 17 of the trial court order, running page 172.
Right. Internal page, mention the internal page, yes. Page 17.
Now, Lord, from the 4th line from top, plaintiff had filed electricity bill for the month of November 2024.
Yes,
showing bill of rupees 120. But the unit billed is 0. Another electricity bill for the month of August 2024 is filed, which is along with a notice of disconnection showing total unit as 0. Again, bill for the month of September, October are filed, and again those bills also show total unit and the unit billed as rupees 0.
Mukherjee, what is your explanation for this?
But suppose, let us not, I will just not, I'll just try to explain. But suppose I am visiting some other place. I am not residing in that property for a temporary period. I am on a visit. So, my lord, that doesn't mean that, my lord, I am not possessing the property. Therefore, my lord, in support of the possession.
Yes, Mr. Mukherjee, was it your case that you went outside or
yes, that is my case.
Was it your case in section 6?
That was not my specific case in section 6 application. I can take your lordship to the relevant paragraph.
All right, you serve a copy Ashok.
And then, my lord, the learned judge also observes that all the other supportive documents are standing in the name of, my lord, the suit premises.
All right.
My lord, may I? Here is this order, my lord, order number. Although I have no right of audience at this stage, since I have not lodged caveat.
Yes.
One line, my lord, I can show, my lord. The FIR, who is my lord, the petitioner lodged, she herself says she was staying with her son and daughter on the particular date when she was outside.
All right. Let us assume that she was not staying, but don't change the nature and character of the suit.
Yes, sure.
Yes.
Only.
So,
yes.
Not to change the nature and character, not to induct any third party, my lord, into the property.
Party rights.
Yes.
My lord, in that our
Where is your application, Mr. Mukherjee, before the district judge under section 115?
That is, my lord,
Lord, the relevant paragraph, your lordship will find at page 70, where I have stated that the urgency, page 70, that relevant paragraph 2021.
22. Well, this is before the honorable learned district judge.
Page 70.
Page?
70.
Yes, before the district judge.
Yes, this is the application, my lord. Paragraph 22, my senior is inviting your lordship's kind attention. 115 year application.
No, induction, there is no prayer. It's only from altering the nature and character on this property. There is no prayer for restraining from creating third party interest.
You are not creating.
That is
Lord,
not.
kindly have a look at, my lord, the next paragraph also, my lord.
But prayer is not there, Mr. Mukherjee.
Lord,
With regard to construction and nature and character, there is no allegation with regard to any induction or creation of.
Lord, the paragraph 23, my lord, your lordship will kindly have a look at. My lord, about, my lord, the fourth line. Whether by making construction thereon or any other manner. The fourth line at paragraph 23.
Yes, to 23, altering whether by making construction or in
Well,
any
that-
whatsoever. Is a vague thing. It's the omnibus prayer. What you are saying, any other such further order of orders.
But at least something about the construction is at least written, my lord. It is not a case where we impute that you kind.
That is what I have said. It's only relates to construction, nothing with regard to induction of third party. Nothing, no application whatsoever in the application itself.
But kindly, my lord, your lordship will kindly do that, my lord. But the prayer is at page 72.
Yes, I've got that. The order. Within 3 months, the suit was disposed of. Suit was. That is the purpose of section 6.
Yes.
This must be this is laudable.
Yes, but for that I have got no complaint against that.
Evidence
But the reasoning is, my lord, that only reasoning, my lord, that the electricity bill showed a zero reading. Whether, my lord, I will be arguing before your lordship about, my lord, the qualitative value of possession in a section 6 application.
That is other things. It's not that you can challenge, but I think the object of section 6 was well appreciated by the learned trial judge. That is the thing. The paragraph being agreed by such judgment and order, the petitioner preferred a civil revision application being number 6 of 2025 before the learned district judge at Howrah. First up, the petitioner prayed for an interim but don't change the nature and character.
We are not changing. We are
I'm
not
only saying that.
We are not at all changing. We are not creating, selling the property or something like that. My lord, only this point, my lord, only this point. What my lord has recorded regarding the consumption of electricity, that has been elaborately discussed by the trial court, and on the basis of my lord,
revision application has been filed pending. Can that finding not be considered by the superior forum? What you are saying?
My lord is recording that will be in effect to be decided. I followed. My lord, the trial court, what the trial court decided, that the FIRC lost or the
all right, I will come to that.
Complaint, my lord, she has, my lord, filed.
This court is inclined to
all
pass
along
an
she was deciding.
interim order. Pushtap, there shall be an order of injunction restraining the opposite party from changing the nature and character of the suit property till the disposal of the till the end of the month of September 2025 or until further orders, whichever is earlier. First up, petitioner is directed to serve a copy of this application upon the learned advocate who has instructions to appear for the opposite party in course of this day, Mr. Bhattacharya.
Yes, yes.
In course of this day, first up, list this matter under the heading contested application in the monthly list of August 2025.
I'm grateful, my lord.
Yes, next.
I'm grateful.
146.
Yes. Yes, Mr. Bhattacharya, this is the matter which you are saying that yesterday you mentioned.
Some other.
You have inquired. Any date has been fixed on that?
Perhaps not some date will be. Vijay, Kalke.
You are making an allegation in the morning first sitting.
Not against.
You are saying yesterday it was mentioned, no date has been fixed. There is urgency.
Takes up this matter. We'll discuss this later.
Yes.
The petition, my lord. Can we see the improved order?
Yes.
Dated 7 February 2025. In that order, the evidence on the part of the defendant is closed, my lord, and argument has been fixed, my lord. Tomorrow is the date for argument. My lord,
what can be done if the witness was not
witness was present? Kindly see page 17, my lord.
Yes, why the witness was not present?
My lord, when the matter was taken up for him, the Lord advocate before the court was engaged in another matter, my lord, for hearing. My lord, at 2:45, the matter was called on, my lord. My lord, kindly see the page 17. My lord, witness was present. Only the my lord. Evidence is very necessary, my lord.
By the order impugned, the
Item number 162, I am for the petitioner.
Yes, Mr. Banerjee.
I'm the opposite party.
Oh, yes.
And I am for the petitioner. My lord, in a suit for preemption, my lord, the allegation of the petitioner preemptor was he is the contagious landowner in respect.
You are the preemptor.
My lord,
I am the PMT.
I have purchased the property already.
You are the PMT.
I am the PMT, my lord.
Yes.
He filed the
preemption on what ground?
My lord, he is the contagious landowner.
Adjoining owner, yes.
Adjoining owner and having the long.
Now, what is the order impugned?
My lord, order 26, rule 9 have done. That was allowed.
Yes.
Challenging the same, my lord, I came before your lordship. The point of, my lord, order 26, rule 9, my lord, for commission work. If your lordship be kind to come to page number 65.
Mr. Banerjee, what is the necessity for local investigation in a preemption on the ground of adjoining owner?
The ground of.
Are there any conflicting claims by two adjoining owners?
Conflicting claim not between the preemptor and preemptee.
PMC is also an adjoining owner.
Also was an adjoining owner. He has purchased it.
Yes.
I lost the claim saying that I am also adjoining owner having longer boundary. So I have a claim of preemption. Now your lordship not pointed out on the last occasion
whether this will apply between two applicants only or between the preemptor and preemptee also. But to that, my lord, my submission first is, my lord, that if not maintenance weight is decided at this stage, my lord, because that is the root of the matter. I say to ascertain whether or not I have longer boundary or he has, from the deeds it is not possible to ascertain. Both of we have the schedule. Both schedules will show the land which is to be, my lord, preempted. But what is the length, my lord, of the adjoining?
West Bengal Land Reforms Act din to? Can I say?
So to ascertain, my lord, who has, my lord, the longer boundary, this fact can be ascertained only by way of investigation. But my lord, the question, my lord, your lordship pointed out whether it is available to me in this case or not. Whether it is between two applicants who are seeking for preemption against a preemptee. On that note, I would not request your lordship not to decide that point at this stage. But I am not fortified with two judgments of your lordship's court, which say that just like it applies between two applicants, will apply before in case of preemptor and preemptee also. This will apply because the statute doesn't bar it. Statute only says between two persons having longer boundary. If your lordship sees not the second, third provision. Third provision, my lord. This has been interpreted. I have the judgments.
Yes, show me the judgment.
One is not 75 AIN, I think 75 Calcutta 290. This is my Honorable Justice Solil Kumar Datta, my lord. Justice Solil Kumar Datta. And the subsequent judgment is also there. There's the subsequent judgment, AIA 79 Calcutta 174.
75 has been considered in 79.
Yeah, has been considered in 79.
So let me see 79.
79.
Takes both.
75 Calcutta. 79 Calcutta 170.
Which paragraph, Mr. Banerjee, in 79?
My lord, paragraph.
My lord, the last paragraph code. My lord, paragraph number 9, if your lordship consider, my lord, then.
Give me a minute. I've got that.
May I place from paragraph 5 onwards, because the facts will also come. Since I am placing only one judgment, lordship will take note from paragraph 7. Circumstances, the determination of the question raised by both. Kindly come from paragraph 5 below. The contentions of the party.
No, Justice Datta held,
No, Justice Datta.
between preemptor and preemptee, it will not apply.
He held that in the view of the court, it should not apply, but the court was helpless because the language was very clear. Court cannot add words to the language, so his lordship allowed the preemption. The previous
No,
one
that
also
is no. In 79, Justice Datta's judgment has been quoted, saying that was the
quoted.
Yes.
That judgment not expressed a view.
All right, give me a.
It expressed a view that it should not apply,
This
but
is
the
a
court said that I am helpless because the language has to be read as it.
Give me a minute.
75 at Lordship will see paragraph 7 of the first judgment first, my lord.
Give me a minute. But the grammatical meaning says otherwise. Because in view of the recent Supreme Court judgment, preemption is a weak right.
It is a weak right, my lord. But my lord,
So if preemption is a weak right,
still it is a right, my lord, to be applied. My lord, Chanarani also, my lord, fortifies the position that my lord contiguous can claim.
No, my lord, I have the reply of
that means Mr. Banerjee,
If your lordship takes.
you are trying to incorporate an exception in subsection 2. Subsection 2, what are only exempted transfers that are being mentioned. So if an adjoining owner purchases this property and
Kindly allow me, my lord, to place paragraph 7 of Justice Doctor's judgment.
no, I've seen 79. 79.
It was quoted in the entire judgment. Ultimately, the court held that no, it will apply between the
No,
preemption
all right,
and preemption.
79. Kindly come to 79 Calcutta. I've seen what you are saying. I've seen that it says, please come to 79 Calcutta,
79
paragraph 9, page 177. In the present case, 10-12 lines from the bottom. In the present case, you have seen 10-12 lines from the bottom. In the present case, the grammatical and ordinary sense, please read that.
In the second proviso, supports the view taken by me as aforesaid and does not give rise to any repugnance, absurdity or inconsistency. A departure from the grammatical and ordinary sense of the words used shall work injustice and give rise to an anomaly. If the second proviso is restricted in its application to only cases of contending preemptors having lands adjoining the land transferred, though the ordinary meaning of the words used does not warrant such a view, a preemptee holding adjoining lands having longest common boundary will have to part with the land transferred, which will go to an owner of adjoining land. Not
So that is the reasoning.
That is the reasoning. And will not, that is the reasoning. So I have a case. I request your lordship not to decide because this point was raised on the last occasion.
Yes, yes, Mr. Banerjee.
It has to be without investigation.
Both Mr. Banerjee.
My lord, Chatterjee,
Oh, Chatterjee. Chatterjee, yes.
My lord, two things. First of all, my lord, the preemption case was filed on two grounds. Contiguous landowner in respect of plot number 732 and 735. In respect of 735, he has the longest common boundary. I have filed the written objection. I have admitted the same. He has the longest common boundary. And in respect of the my lord, written objection has not been given, my lord. That was my mistake, my lord.
No, you have admitted that.
I have admitted
Then
that.
it's the end of the matter. Local investigation is not necessary, Mr. Banerjee.
Other than, my lord,
where is the application for preemption?
My lord, may I have not submitted.
No, application is here.
Objection, my lord. Subsequently, I got to know the objection was filed, my lord.
No, there are two plots, 732 and 735.
There are two plots, my lord. In respect of 735, my lord, he has purchased the property from someone else, from a third-party stranger. In respect of 732, my lord, he has received the property by virtue of a partition.
Preemption is in respect of Schedule A.
Schedule A, my lord.
Schedule A. Schedule A is plot number 731. So you have purchased a share in 731.
I have purchased not a share, my lord. Not a share. The total share of 730.
Right. Portion of 731. Where is the deed?
My lord, deed is in page number 35, if your lordship kindly consider. The periphery of the plot number 731. That is mentioned in page number 35 of the application.
Yes, so
my lord,
one is 735 is a contiguous plot. 732 is also a contiguous
plot.
All right.
Now, my lord.
So 732, you are also owning 732.
No, I am not owing 732.
I am owning 732.
He is owning 732.
You are owning 732 and you are owning 735.
I am owning half of 735.
You are owning
portion of 735, not
735.
I also own a portion of 735.
So, whether this, you also own a portion of 735.
So, who is having the land?
Which is to be, because totaling because 731 The boundary of 731 is 732 and 735, both.
No, my lord, not in the,
Give me that sketch map. 731 is the suit plot. 735 and 732, both are contiguous. So
30 is also contiguous. He is having 730 and a portion in 735.
730 is, you do not have 730.
I don't have 730. He has 730.
He has 730.
I have, my lord, 732 and a
Just
portion of 730.
732 entire yours.
Entirely mine.
And 735 portion yours.
Portion in gold is mine.
So now entire boundary of 732 and 731 and 731 and 735 is to be measured, and your boundary of 730. So it requires.
my lord, I have admitted the same, my lord, that he has the longest common boundary in respect of 735 in my written objection, my lord.
Not only 735, 731 is to be measured, 732. So who is the longest common boundary? Because he has boundaries on two sides. So longest,
Two sides.
everything on two sides. So you are only saying 735, you are not saying 732.
Subject to correction.
And if you admit that yes, he has the longest common boundary, end of the matter.
In respect, I have already admitted, my lord, in my written objection.
That will amount to, my lord.
He has the longest
Case
common
will
boundary.
go.
I have, my lord, para-wise, I
Your
have
case
denied.
will go then. What are you saying?
My lord, one thing, my lord, before.
Let the local investigation be held.
One thing, my lord, one thing.
It has already
In
taken place.
respect of 732, my lord, he is the
Because the
contiguous.
grammatical meaning is otherwise. My impression was also that.
That is the view of Justice, Honorable Justice Dotto. If your lordship takes up that judgment,
Yes.
lordship in paragraph 7, kindly see paragraph 7 once, very interesting. His lordship says that normally it should be between two applicants only.
Yes.
But since the language is, we cannot go beyond the language, so it has to be allowed in case of preemptor and preemptive also. Paragraph 7.
Paragraph 7.
Right.
Yes.
One thing, my lord, in respect of
I'm
732.
not making this at this stage, Kiola.
In respect of 732, my lord, he is the contagious landowner. He can claim in respect of the 732 as well. If they want to claim the preemption, he can claim in respect of the 732 as well.
732 has not filed. How can he claim now 732? This application under article.
No, my lord, he has the, my lord, he has the allegation that he is claiming the.
Thing will happen. The commissioner will only measure. If he is not
My lord, that is tantamount to collecting of evidence, my lord, on behalf of them.
Some amount of collection of evidence is permissible by local inspection.
On behalf of them, my lord, because
Not
the
on behalf of
topographical
them.
possession of the suit
Not on,
properties will be.
not on behalf of them, because the statute requires. This is the statutory requirement. Who is the longest? So for the purpose of deciding that, court has to do that. It's the court's requirement, not the party's requirement. The statute says so. This application under Article 227 of the Yes.
234. 234, my lord, Mr. Kushal Chatterjee is appearing, my lord, this way.
I am for the opposite party, my lord.
My lord, my lord, I do not know how this matter came up because it was
On
not
my
mentioned.
instance, this
My lord, we have not been served with any notice, my
You are
lord.
the opposite party.
Yes,
You have mentioned without serving him a notice.
I have personally informed Mr. Kushal Chatterjee.
Lord.
He knows. Mr. Kushal Chatterjee knows. Every time I, my lord, mention, I communicate to Mr. Kushal Chatterjee. His
Lord,
is also
my,
there.
Yes, what is this matter? Yes.
my lord, he is out of court, my lord. He is,
Yes,
he has
he
been.
You are here. Please start. Yes.
Today, my lord, kindly consider how I am suffering. I am not getting, my lord, any occupational charges. The tenants had already suffered a degree of eviction. Now, more than 6 lakhs rupees are pending as occupational charges. In 20th, my lord, the appeal tendered by them are going to be, my lord, come to an end. And 5th of next
So
month.
they have not paid.
No, they are not paid.
So it has vacated.
No, my lord,
It's
kindly
vacated.
No, my lord, my lord, kindly comes to the impugned order for.
Yes.
On the first page, my lord, at the bottom portion, my lord. May I read it? Having heard the learned counsels, considering the materials on record as well as the submissions as advanced by the learned counsels, and also considering the location of the suit premises and the purpose for which it is being used, the court noted the occupational charge of the suit shop room at rupees 175 per square feet for 300 square feet. Now that is where we are aggrieved, my lord. My lord, the tenanted portion is of 150 square feet and not 300 square feet, my lord. If my lord kindly takes up the commissioner's report for once, my lord.
Where is the plaint?
My lord,
Where is the decree?
my lord,
Degree,
that
my lord,
has not been
I have
annexed with
degree
the.
with me. But my
Sir, please take your seat, sir. You are the opposite party. Please take your seat.
My lord, the decree is not decree and the plaint is not annexed with the my lord, the divisional application. But my lord, if my lord kindly comes to the page number 26, which is the commissioner's report.
Yes.
My lord, kindly turns over page number 27.
Yes.
My lord, in the measurement portion, it has been clearly stated that the north to south 10 feet, east to west about 14 feet 10 inches. My lord, the tenanted portion is of 150 square feet and not of 300 square feet, my lord.
Yes.
Now, my lord, as far as my instruction is concerned, my clients are ready and willing to pay the occupational charges, but not for 300 square feet, but for 150 square feet, my lord. My lord, that is where we are aggrieved and we have come before this court. Now, my lord, the decree is also on the part of 150 square feet, not of 300 square feet, my lord.
Decrease for 150.
Yes, my lord.
Yes. Anything more? Yes. Yes.
My lord, I am not. My lord, kindly grant me an
Yes.
opportunity.
the schedule of the plaint, my lord, there is.
What is the measurement? What is the measurement of?
No, my lord.
No.
Show me the plaint.
My lord, plaint I don't have with me to
Decree.
My lord,
decree I have.
my lord,
Show me.
the agreement. My lord.
Yes.
Excuse me for the marking, my lord. At the bottom portion, it has been clearly stated it is a 150 square feet, includes the mezzanine floor. At the bottom portion, my lord. Agreement.
Oh, agreement. Yes, my lord. Kindly see agreement also I have. It says, my lord, 16
And
feet
in
height
the
of the.
kindly. In the impugned order itself, my lord. If my lord kindly comes to the first paragraph of the impugned order.
Where is the decree?
Decree I have just handed over.
So any mention of the area?
No, nothing is mentioned.
Yes. So in the agreement, what is the measurement?
150 square feet, my lord.
Measurement is 150 square feet, but there are, my lord, 2 floors. That is also recorded. One in the commissioner's report. That mezzanine.
Yes, show me that.
Kindly come to page 26. Now the commissioner said, my lord, one middle portion that my learned just showed. One cemented block ceiling and square cutting area from southeast corner to said room, which can be used as go down of dumping area.
Page 26.
Page 26.
Yes.
So what commissioner?
Yes.
And Milord may kindly compare the commissioner's report, this portion, and the rent agreement. The rent agreement says 15 feet into 10 feet and height is 16 feet. Now, if it is 16 feet, then mezzanine floor is obviously there.
Mezzanine floor is a part of the tenant agreement, my lord.
Then if mezzanine floor
It
is
in-
there,
that includes within that
Oh.
150 square feet, my lord.
Where there is two floors,
No,
mezzanine
my lord.
floor.
To my instructions, my lord, the tenanted portion includes the mezzanine floor as well, which is including 150 square feet in total, not 150 square feet separately 300 square feet.
All right.
And if my lord kindly comes to the impugn order for once. My lord kindly comes to the impugn order for once.
Yes.
My lord, the very first paragraph. May I read it for your lordship?
Yes.
It is submitted by the learned counsel for the appellants that the property is situated on the ground floor of premises number such and such, Park Street on the main road of Newmarket, and is measuring about 120 square feet, lordship. It is our very specific case that perhaps it has been wrongly recorded as 120, but it has always been 150 square feet and not 300 square feet, your lordship.
if it is not three, it is said we have.
My lord,
said
the
it's three-
degree is of 150 square feet.
No, in
The
nowhere
commissioner's
in the
report is
degree
of 150 square feet, my lord.
in nowhere.
The degree has been passed on the basis of commissioner's report, my lord.
In the schedule,
It has been 150 square feet. How can the executing court go beyond the
commissioner's report is not a part of decree. It was and commissioner is not a measurement
commissioner's
expert.
report is a part of the
No, it is not a.
commissioner's
What are you saying? Commissioner's report is not,
part of the
it's not part of the degree.
No, no,
I'm setting aside that. Your degree will go.
No,
What
no,
are you
sir.
saying?
Kindly see.
Eviction suit on the basis of the commissioner's report. All right, I'm recording that. I'm setting aside the
Much
commissioner's
obliged.
report.
I am not.
You're saying so. Commissioner's report is not expert, not considered, not part of the. What are you saying? That is the very basis of your decree.
Then kindly consider the other aspects also.
Yes.
Kindly see, my lord.
Are you interested in the money or you are interested in the disposal of the appeal?
Appeal will be disposed of in 20th of this month, my lord.
Disposed of?
Will be disposed of. They have already completed their submission. Only our part is remaining. 20th it will be over. And 5th of next month is my lord execution proceeding. So I am only prayer is if I am if their appeal is dismissed, I may not be prevented in 5th of June in the execution proceeding.
How you will prevent it? If the appeal is dismissed,
Because the stay
stays in the is in connection with the appeal. If the appeal is
no stay in connection with execution proceeding.
as the appeal has been preferred. Ashun, this application under Article 227 of the Constitution Yes.
Lord, the father
Calcutta.
is with your lordship.
For the
petition,
mother,
Lord. Lord.
Lord, I
Yes.
was appointed as a special officer, my lord, to
Special officer.
yes, remain present, my lord, at the time, my lord, when the birthday celebration, my lord, the father was to celebrate the birthday of the child, younger.
What happened? What is the dispute?
The dispute is with respect to, my lord, a restitution of conjugal rights has been filed.
Yes.
Now, my lord, in that an application for visitation was filed. My lord, asking visitation for
You are
weekend.
you are
Father.
You are the father.
Father.
Child is with the mother.
Yes. I am incurring all expenses, whatever is required, my lord, I am incurring everything.
Oh, this is that matter.
Lord, what I am wanting is, my lord, the weekends and, my lord, the vacations, if a shared parenting, my lord, can be, my lord, granted to me.
So apply before the.
That's exactly what I've done. That is exactly what I've done.
That was rejected.
Yes, court rejected in a, my lord, cryptical manner, just stating that very well for 1 hour you go there and
All right.
My
Give me the report.
my
Have you circulated this report?
No, my lord, till now.
Cut.
Well, may I submit, my lord? Subsequently, matter was heard. After the
yes.
order was passed, my lord, the is no need of this petition, my lord. It has been extended, my lord. Time period.
What extended?
Nothing has been extended. You take a look into it.
Kindly consider the last paragraph, my lord.
No, not only last paragraph. Your lordship
What has been extended?
Lord, what had happened is, Lord, certain complaint was made for modification because of the timing of the school. Of the school timing, a modification was applied for by, Lord, the opposite party here. Lord, in their application, a modification was granted that instead of, Lord, going to Barashat.
Give me a minute.
My lord.
লিখেও দিয়েছি আমি লিখে
আমরা ওটা ভাড়া বাড়িয়ে বিক্রি করি। কোনো অবজেকশন আছে?
money to report.
So what?
Show me the impugned order.
Kindly, my lord, comes to the last, my lord, 20th of June. Not records everything. Kindly straight away, my lord, comes to.
No, one thing, this was directed to produce before the every Wednesday before the DLSA. DLSA may not be a congenial.
That has been modified. That has been modified by the order my learned friend has given to your lordship.
Where it has been made now?
Lord, it has been made in the chamber. That also for 1 hour.
In the chamber of?
Chamber of Lord Advocates Chamber.
Of
3 to 5.
Of the petitioner means your advocate's chamber. 3 to 5.
3 to 5.
2 hours.
Mr. 2 children, Lord. There are 2 children. I have, Lord, my father, mother in my family. Everybody is there. Your lordship knows, Lord, the one is 8 years old, the other one is 6.5 years old.
Since how long this is continuing?
Lord, 23rd of November 2023, she left home with the kids.
No.
Thereafter, Lord, I am trying.
This visitation is continuing for how much time?
Lord, immediately after impugned order, I came up with this honorable court. Lord, they had.
So by that order, you said
stop complying with that.
All right. To start, please first start with the situation, because for the timing, I think 2 hours. Start with 2 hours. I will allow you to apply if the situation, Mr. Kormakar, in one day the situation may not improve.
That's
so
exactly
for the present, advocates chamber, this is on each and every second Sunday, 3 to 5, and on 4th Sunday 3 to 5.
What is where is the finding that these are the reasons why, my lord, I am not entitled to
Mr.
this?
Kormakar, there are two things. This order is not under challenge. First. First, do one thing.
Your
You,
lordship under 227 can take cognizance of this, my lord.
then you have to challenge. There is another thing. Then one thing in for me to modify this, unless this is challenged, it cannot be modified. I can do one thing. Please start with this.
Lord,
I
have
will give
already-
you liberty. I will record your submission. If situation improves, you will be at liberty to approach the learned trial judge.
Difficulties, Lord, kindly considers this. Lord, I will only have 2 days in a month for 2 hours to have my children. Lord, at
Mr.
least
Kormukar,
what your lordship is,
yes,
what is
please start with that for some months. Thereafter, it can be increased. Now for month,
may
you are getting 2 days for 2 hours. Please start with that.
Lord, may I suggest this? For starting, keeps this revision application pending. Lord, keeps it.
I will give you
Else
liberty.
Again.
I will, because Mr. Kormukar, you have to go there for modification.
My application has been disposed of.
Which application?
Visitation rights. That application has been disposed of.
That liberty I will.
And Lord, I do not know,
Mr.
after
Kormukar,
disposing of that application, how the court
your
would have
application-
modified this.
Mr. Kormukar, your application has not been disposed of.
My lord, kindly comes.
You are given liberty to meet your child in the office of the TLSA.
Lord, kindly comes to the last page of the impugned order.
Yes.
Thus, the petition dated such and such is hereby considered allowed in contest without cost, and so it's disposed of.
Yes, that was allowed in part for that part. So, with the passage of time, you can file a fresh application. I will give you that
Lord,
liberty.
I can always do.
I
Lord,
will
what
give
I'm
you that
on-
liberty.
What I'm on is, Lord, if today, Lord, this is nascent stage. If today, at least a week, I do not get, once in a week.
Kormukar, please start with that. How long you have not met your child? It's, I think, on that day is the last day.
After this order, my lord, I am told, my lord, on 2 occasions. Two occasions, my lord, I am told, my lord.
So 10th of March was the last. No,
This is 13th of May.
13th of May is the last.
13th
So-
of May is the last order.
So prior to that was on 11th of March.
They did not comply. I did not meet.
No.
I came up with your lordship. This
Yes.
order was passed. Not the special officer was there. Whatever was done. Thereafter, this modification application, this order was passed. After that, not 25th of May and 8th of June, I have seen my children. So, my lord, my suggestion before your
Mr.
lordship.
Chatterjee, can it not be on
Why
every
has it not-
Saturdays?
My lord,
What is the difficulty?
Difficulty, but there are other co-curricular activities, my lord.
What co-curricular
I will
activities?
take care of that.
What co-curricular activities?
After all, I will take the instruction. What are the how they have been placed, my lord, during that time, my lord.
Sir, Chatterjee, Sunday, I don't think the entire day the co-curricular activities will go on. Living apart that period, the father can
Let
be,
them start, my lord.
they will start.
They start. Let them start, my lord. I'm not opposing. Let them start, my lord. Then the door is always
Where
open.
is the difficulty? A son will meet his father. Where is the difficulty? I don't understand.
Why are you
Where is the
objecting to
allegation
that?
that I'm not entitled to be a
Why are
father?
you objecting to that?
My lord knows, my lord. My objection.
What is the difficulty?
Already, my lord, recorded, my lord.
What?
Already recorded in the impugned order, my lord. My objections.
No. Objections are there. If in a month on 2 Sundays, what is the difficulty in the other 2 Sundays? Let them start with that.
But let's start with 2 Sundays later, my lord.
Why this objection is coming?
Why? What is the real ground? What is the real ground? Let the
My lord,
after all, the sons also have to meet, also have to have the company of the father. So you are having company of the son for the entire week. You cannot spare for 2 hours. If you want, you can please take instructions. If you say yes, from 3 to 5, for those Sundays there is difficulty, give a convenient 2-hour time on the other 2 Sundays.
Take instruction, my lord.
That Mr. Kormukar's client has to agree to that.
For the time being, I'm ready to for that. For the time being, I'm ready for that.
If you are saying that curricular activities and the father can also take care of that.
I will not
If
take
he has
care
to
of
attend
everything.
some classes, father can take care of that.
Just not 3 kilometers, because they reside in Salt Lake, block AA, and they reside in Lake Town. So not even a matter of 15 minutes.
Father is so eager, they may come to my house also.
Why not this kind of
House is a difficult thing. Don't entertain that because the advocates, the learned advocate is whose advocate? Your advocate.
My lord.
Your advocate. before the learned trial judge. So the mother will bring to your advocate's chamber.
What,
So I
what
think
can
it's
be
better.
done is I can for 2 hours, what I can do is I can collect my son or not sons from their house.
What is the next, it is first and
Sunday.
no,
So this Sunday we can do it.
second and fourth.
Fourth.
So this Sunday is which Sunday?
This Sunday is
Coming
second
Sunday?
Second Sunday.
So second Sunday you are getting
My
as per this order.
My lord.
So I am keeping it in the next week.
Very well. Very
So
well.
Chatterjee, please take instructions.
And my lord, if possible, my lord, I can collect the sons from my from her residence and again, my lord, leave them.
Mr. Kormokar, you and Mr. Chatterjee, please have a talk with your client. Both of you talk together and make a suitable, convenient time. Ashun. 15th is Yes, yes, call the next matter.
286.
What we will do with the tenancy agreement? The appeal is now we are at the final stage. Yes, sir, we will get back. Don't have to scratch your head.
No, not get back. Not only thing.
Yes.
Matter is over now.
My lord,
I'm for the opposite party.
my lord, Mr. Raut is appearing. My lord, he attended the court in the morning. But in the second term, my lord, he feeling very.
You mentioned, you mentioned.
Yes, admitted, my lord. Collect tomorrow at
This matter.
T20.
I could stomach problem. He left the court once.
You have to be made ready. You have to make this up. When you are mentioning, you have to take that chance. Not possible to take up every day.
But please, Your Lordship, I am appearing on behalf of the petitioner.
Yes.
The petitioner is the defendant tenant in the suit below. This is a suit for eviction, recovery of khas possession, mean profit and permanent injunction filed by the opposite party. We took out an application under Order 7 Rule 11 on the ground that the suit is barred by law and there is no cause of action disclosed in the plaint. Now, on the basis of that, we relied upon a Supreme Court, Honorable Supreme Court's judgment, which says that our contention was our tenancy is a heritable tenancy, which is still continuing under the old Act, Premises Tenancy Act 1956.
So you have paid for rejection of
plaint.
Yes.
Now, on the basis of that, our application was dismissed by the impugned order. Let kindly come to internal page 1, 2, 3 of the impugned order.
Yes.
Second last paragraph, which begins from now. That is internal page 3 of the impugned order.
Yes.
Now,
yes.
Now, if I may go through it, this is probably the observation of the learned court below, which says that the plaint itself, it appears that the plaintiff have instituted the suit for eviction against the tenant on ground of 2G, as because the original inducted tenant, Gopi Ballabh Chaturbedi, died on such and such in the year 98, leaving behind his widow, Suman Chaturvedi, and his son, defendant number 1 herein, and 3 daughters. It has been pleaded in the plaint case that the Suman Chaturvedi only inherited the tenancy right under the previous 1956 and following the provision of 2G of the present Act of 97, the present defendants have no right of tenancy in respect of the suit property. Defendants have raised the point of rejection of the plaint on the ground that not Suman Chaturvedi alone, but also her children also inherited the right of tenancy, and therefore provision of section 2G of the new act cannot be made applicable. Normally,
yes, how this suit is maintainable?
My lord, if my lord takes up the plaint once, my lord, the
suit under section 2G.
The original tenant died
when?
1998.
So,
suit filed in
recent decision. Have you considered the recent decision of the Supreme Court?
My lord, if my lord takes up once section 2G,
sir, that has been interpreted by the Honorable Supreme Court. Have you considered that, or you want to consider?
Then I will consider that, my lord.
All right.
Okay. But my lord, but my lord, give me 1 minute time, my lord. My lord, over here, the second defendant, the widow has passed away in 2020.
Sir, 2G has been interpreted. Please consider that judgment. Ashun. 44.
44.
I had mentioned the matter, my lords. My learned friend appearing for the opposite party has just informed me that his
My lord,
there is
in
no
this matter,
Mr. Nimish Mishra is appearing. His
oh, this is yesterday's matter.
yesterday.
Yes.
Mr. Mishra's mother has fallen unwell and he had to rush to hospital. She's on
I'm
dialysis.
making it not today.
My lords, the DRAT is also fortunately for
Not
me, my
sitting.
lords, not sitting tomorrow.
DRAT. Oh,
So, so my lords will kindly keep it on Monday if my lords so pleases, my
this
lords.
is appearing. I do not know what is Mr. Mishra. Then, what is the next date fixed?
Not yet fixed.
Please
It was
take
yes-
instructions, then mention.
It was fixed tomorrow. It will be fixed tomorrow, my lords.
It is remaining in the list. It will be called. Yes, next. Pass over next.
34.
Your Lordship, this revisional application has been filed for expediting a complaint case, which is filed before the District Consumer Redressal Forum, Unit 4. The complaint case is at the stage of hearing, final hearing.
What is the next date fixed?
Next date is 13/8/2025.
13/8?
2025, 13th August 2025. Order. And since last year, since 1 year, it is they're taking adjournments. If your Lordship comes to order number 12, they have been directed that to filing the BNA by both the parties in the meantime.
Ashok, this application under Article 227 of the Constitution of India is at the yes.
And for the petitioner, my lord, husband responding the suit, my lord, order of maintenance given.
Husband?
Husband, who is the petitioner before your lordship, suffered an order of maintenance to the tune of 30,000, my lord. By an order, my lord, which I say, my lord, without any finding as to my income, without any finding as to the income of the wife. Both are earning.
Considering the status of the advocate, the alimony appears to be correct.
But, this man, he has a company.
What is your income, Mr. Banerjee?
My income, I have disclosed my income.
No, what is the finding?
No, it's not. There's no finding at all, Milord, regarding my income. Wife, admittedly, wife has an interior decoration business. She has not disclosed her previous income. I have annexed not the income tax return for her 5-6 years, Milord. She is having an income. No finding as to that, Milord, also. Kindly see, Milord. After discussing the respective cases, the finding part is, Milord, from page 3 of the impugned order, kindly see, Milord, no finding. Discussing the judgments, then, in light of
The brand of the car which you are using,
that is the allegation of the wife, Milord.
you are not using.
No,
What
no,
is the brand you are using?
Milord, none of the cars mentioned in the order, Milord, is belongs to the husband. And the wife is having, Milord, a separate interior decoration business in her name. That is admitted.
You are also a real estate agent.
No, wife. That is the allegation, Milord. Wife is the agent and she is having an interior decoration business in her name for which files income tax return, but not showing any income from that. So she is actually suppressing, Milord, the income. Kindly comes to a finding, Milord, there is nothing. Absolutely cryptic. After discussing,
There is substance in the argument. There is. Yes.
In this matter, my lord, I'm challenging the order dated 3rd October 2024, passed in title suit number 575 of 2024 by the learned civil judge, Junior Division, 4th Court at Purbo Bardhaman.
What is the order impugned?
Page 22, my lord.
1st of October or 1st of October?
3rd October, my lord.
Yes. Injunction?
Permanent injunction, my lord.
Yes. By refusal to pass an injunction.
Rejected
That
the
is order number 3, order dated 3rd of October.
3rd of October, rejected the prayer for temporary injunction, petition only.
You are agreed by that?
Yes, my lord.
It's an appellable order, madam. Yes.
37.
My order 1 rule 10 application has been rejected. Admittedly, I am 40% undivided owner of the property. The deeds under challenge.
What is the suit for?
Suit for declaration injunction. I filed an addition of party. The plaintiff admitted that I have the ownership. Even then, the defendant came and say, no, he has no ownership, though in WS they admitted the same. This should travel up to this court in a first appeal where your lordship was pleased to. There in the appellate court, your lordship, there is an order of the appellate court, my lord, where it has.
Where is the plaint?
Lord, plaint of this suit, my lord. Lord, your lordship can find page 15. It starts from, my lord, page 14. We have certified copy, it's page 12. This is certified copy.
No, this is a suit for cancellation of a deed of sale. Are you a party to the deed of sale?
I am a party of the deed of sale. I am the party of the deed of sale.
Where is the deed of sale?
The sale, that sale deed has not been annexed.
Yes.
They kindly have a look in the order impugned. The plaintiff himself admits.
Show me the deed of sale.
Lord, deed of sale has not been annexed in the divisional application. As Lord, that was not the part of the before the trial court. Lord, the plaintiff himself admits that I am the party of the. I am 40% undivided owner of this portion.
Do you have the copy of the sale deed?
I have the copy, but
not today. Please bring on the next day. Because that is necessary. If you are not a party to the sale deed, you are not a necessary party. The learned advocate appearing for the petitioner.
No.
Contempt application 331.
Yes. None appears for the petitioner at the time of call. No accommodation has been sought for either.
My lord, lordship was kind enough to pass order in the year 2022, page 49.
Yes.
Then, my lord, after a considerable period of time, we have filed our contempt application. My lord, they have preferred appeal. My lord, the appellate court was.
They have preferred appeal.
After filing contempt application.
Yes.
That is why all the papers are not
just
like.
To be, I'm adjourning this.
Yes. No. Why, my lord? On the last occasion, they took time further after Supreme Court upheld the judgment passed by this honorable court. My lord, they took 2 months time.
Oh, up to
yes, up to Supreme Court. This is my lord.
It is pending.
So, my lord, they have nothing to say, my lord. That is why they are skipping this honorable court.
Which matter?
My lord, that is in the Factory Act matter, where, my lord, the overtime allowances is required to be paid.
So Mr. Ghosh is appearing.
On the last occasion, Mr. Ghosh assured, my lord, in the month of January, within 2 months,
Where
we
is
will take
Mr.
care
Ghosh?
of it.
Where is Mr. Ghosh?
Possibly, my lord, he is not coming. No instruction is available as far.
Then I'm issuing a rule.
Yes, my lord, that is why, my lord, I'm praying.
Uh,
The municipal commissioner, my lord, meanwhile has changed.
Mr. Chakraborty, learned advocate appearing for
The requisite and other things is required.
yes, next.
Triple three.
Order has not yet been fully complied with. Some of my clients have been paid, others have not been paid.
Some have been paid.
Some have been paid, although in the month of February.
Who is appearing for the alleged contemner?
Yes, Mr. Dhiron Sengupta, Oin Chakraborty, and Mrs. Sunini Mukherjee.
Where are they? Because it has been complied with in respect of some.
But as far as attend with 335, there are 3 matters. 335 is concerned, my lord, my clients has been paid day before yesterday, but less. I was paying, my lord, if they can bring on record, my lord, the calculation. Because
nobody is here. Whom shall I direct? I'm making it not today, next day.
We shall give a notice.
Not the petitioner is three 334, 335. তিনটেই একই order. Next.
For 88 years, your lady has in a bedridden condition, my lord. She has not getting her family pension. My lord, kindly come to the place. My lord, this is the order dated 24th January.
Yes, where is Mr.
Your lordship has.
Where is Mr. Tapan Mukherjee?
My lord, intentionally they are doing.
All right.
This is the affidavit of service, your lordship.
Every service filed in court. Yes.
Applicant, my lord, I have paid for extension of time, complying with the order.
Extension of time.
Yes, my lord, for.
But where is the petitioner?
Devjan Sengupta, my lord, he had already filed. Though I filed application for extension of time earlier, filing the contempt application, my lord. Admitted position, but
Where is the, have you served the copy upon the other side?
my lord, upon service,
Where is Miss Sengupta? No, they are not appearing. How much time you want?
at least 3 months, my lord.
3 months.
Inquiry is going on, my lord. May I hand up the
This order was.
lost this order. What happened, my lord? Actually, earlier they preferred an appeal, and an appeal was ultimately withdrawn. Thereafter, they.
All right, I'm keeping it in the next week. None appears for the petitioner. First of the learned advocate.
My lord, extension of time, my lord,
Extension of time. I have not directed you to make any inquiry.
yes, my lord.
Yes, all right. Yes, call the next matter.
My lord, directed, my lord.
Yes. In their presence, bring them.
My lord, I beg to appeal. My lord, the ad interim injunction passed in favor of the, my lord, plaintiff. Thereafter, my lord, order violated. And my lord, the police assistance order has been passed under section 151 by the, my lord, learned trial court. And against the inaction of the, my lord, police, my lord, the petition has been filed before your lordships. And your lordships, my lord, passed the order page number 11. And my lord, the operating part is, my lord, to comply with the order of the learned trial court dated 14th of May.
For the first time.
First time, my lord.
Petitioner is directed to serve. The contempt application after 4 weeks. Yes, next. Yes. এটা কি? এটা কি contempt? এটা first time? Huh? Petitioner is the copy of the আর আছে?
May I mention one minute? For item number 42, today's list.
Item number
42.
Yes, what happened?
Can it be fixed tomorrow at 2 p.m.?
Why? What is the urgency?
No,
42, I appear for the plaintiff opposite party.
42 is expected to be taken up to tomorrow.